Welcome to the second International Workshop of the Network of Philosophy of Private Law, here at the University Internacional de Colombia. We are grateful for your presence. Sorry, I'm gonna click down. First, we will begin with some words from our president, Hernando Barranquilla. Then, words of our director of the Civil Law Department, Professor Milagros Cotech. Then, some words of our director of the Research Center of Philosophy and Law, Professor Carmen Ruiz, who is virtually. And finally, words from the coordinator of the Network of Philosophy of Private Law, Professor Alexander Vargas. Professor Hernando Barranquilla, you have the floor. You have the floor.
Good morning to all of you and welcome to our University Internacional de Colombia. Esteemed guest professors, Anita Bernstein, professor at Brooklyn Law School, and Gregory Keating, professor at the University of Southern California, and Maya Guadalupe Martinez, professor at the University, Diego Papayanes, professor at the University of Girona, Esteban Pereira Fretz, professor at the University Adolfo Ibáñez, Arthur Ripstein, professor at the University of Toronto, Professor Alexander Vargas Tinoco, coordinator of Private Law Philosophy Network at our university, Professor Carmen Eloisa Ruiz, Director of Research Center and Philosophy and Law, Professor Milagros Cotech, Director at Civil Law Department, Dean Professor Emilio González de Cancino, Dean of Faculty of Law, Professor María Alejandra Díaz, Ricardo Arenas, Pablo Venegas, members of the Research Center in Philosophy and Law, assistant professors, students, and distinguished guests. It's about an honor and a privilege to extend the warmest welcome to all of you at the second International Workshop on Private Law Philosophy, hosted here at esteemed Externado de Colombia University. The convening of this workshop in Colombia, an initiative of the Private Law Philosophy Network, which our university has been part of since 2020, in collaboration with the University of Girona of Spain and Adolfo Suárez University of Chile, marks a moment of intellectual and academic jubilation. It brings us together to delve deeply into a realm of law in area vital to legal framework of any society, particularly in governing private initiative and interpersonal relationships. Engaging in philosophical discourse in this 21st century presents a unique challenge. In a world characterized by rapidity and inundation of information via the internet, the consumption of knowledge has become increasingly voracious, often at the expense of the quality and evaluated standards. Philosophical reflection has become more imperative than ever, as a means fleeting trends and constant appeals to emotion. Deliberate and profound contemplation allowed us to ground our worldview and adopt more conscious understanding of ourselves, our behavior, and our interactions with others. It is within this context that private law is directly addressing interpersonal relations assume profound significance in its roots and foundation. The manner in which we interact across various geographic spheres often falls short of justice, necessitating thorough evaluation and analysis to pave the way for the construction of better, more peaceful, and more developed communities. Indeed, this is the essence of philosophy, to visit the treasures of knowledge, not only to analyze them, but also to question them. In this regard, Aristotle's description of corrective justice invites numerous inquiries into its relevance within our current context. One might wonder whether the concept of corrective justice is sufficiently just in regulating our interactions with others. This is pertinent because at times the interacting parties are so unequal in certain aspects that the formal equality proposed of corrective justice will yield disproportionate and unjust solutions in other respects. Over the next 2 days, we will have the opportunity to engage in profound debates, exchange ideas, and enrich ourselves with the knowledge and experience of our speakers and participants. It will be a space for critical reflection, respectful dialogue, and the collective constructions of new horizons, ideas emblematic of our institution. Allow me to conclude by expressing my sincere gratitude to all of those who have made this event possible, to our speakers for the generosity, sharing their wisdom with us, to the organizers for their dedication and endeavor in bringing us this undertaking and vision, to all of you, dear attendees, for your interest and commitment to legal knowledge. May this second international workshop on private law by laws further space for learning, reflection, and collaboration. It may our deliberations contribute to the strengthening of our legal systems that is more just, equitable, and human. Count on University External as your academic home as we pursue this discussion and continue proposing solutions to our daily legal challenge. Thank you very much. Welcome again.
Thank you, Professor Parra. Now, we welcome Professor Milagros Cottage, the Director of the Department of Civil Law.
Good morning. Welcome, everybody. Señor Rector, Hernando Parra Nieto, señora Directora del Centro de Investigación en Filosofía y Derecho, doctora Carmen Luisa Ruiz, respetados profesores invitados, Anita Bernstein, Gregory Keating, María Guadalupe Martínez, Esteban Pereira, Arthur Ripstein, Diego Papayanis, doctor Alexander Vargas Hinojo, profesor del Departamento de Derecho Civil de la Universidad. Apreciados profesores y demás estudiantes o asistentes a este encuentro académico, reciban de parte del Departamento de Derecho Civil la más calurosa bienvenida a esta su casa. En esta oportunidad nos hemos dado cita para presenciar el segundo workshop internacional de la Red de Filosofía del Derecho Privado, en el que se abordarán por parte de los destacados profesores que nos visitan muy diversas temáticas, como el perjuicio reparable o irreparable, inclusive la importancia del actor privado en materia de daños, la relación entre lo público y lo privado a propósito del Law of Public Nuisance, luego de lo cual, aunque no menos importante, este encuentro académico abordará en materia contractual los límites de la solidaridad, la irrupción de la justicia distributiva en el derecho privado y cerrará con un balance del encuentro, del que todos seguramente recabaremos nuevos e interesantes interrogantes, temas de análisis. Este encuentro, organizado y coordinado por el Centro de Investigación en Filosofía y Derecho de la Universidad y el Departamento de Derecho Civil, es constituye la concreción del trabajo que se viene desarrollando desde hace ya algunos años en aras de promocionar la filosofía del derecho privado como área de fructífero estudio para la academia, presentando al público las investigaciones de los docentes, a quienes, una vez más, agradecemos muy sinceramente por su participación. Para finalizar, no puedo dejar de agradecer a las universidades que integran la red de filosofía del derecho privado: Universidad de Girona, Universidad Adolfo Ibáñez y nuestra universidad, por el gran trabajo que realizan. Agradezco de manera particular, especial, al profesor Vargas Tinoco, vocero y coordinador ante nuestra universidad de la red, por su dedicada participación y acompañamiento en la estructuración de este evento, así como al Centro de Investigación en Filosofía y Derecho, al cual extendemos nuestra más sincera felicitación por sus 30 años de vida y exitoso funcionamiento. Muchas gracias.
Thank you, Professor Milagros Cottage. Now we will have the words of our Research Center of Philosophy and Law Director, Professor Carmen Eloisa Ruiz.
Buenos días, muchas gracias, María Alejandra. Buenos días, señor rector Hernando Parra Nieto, profesora Milagros Cottage, profesores invitados, colegas, señoras y señores, a todos los asistentes, personal que se encuentra online y a los demás asistentes. Creo que es unánime la voz de bienvenida al equipo de trabajo de profesores, de investigadores a este importante espacio para la discusión sobre fundamentos en derecho privado, que como ocurre en la mayoría de los temas y cuando estamos hablando de fundamentos es transversal para la discusión en todas las áreas del derecho. No es la primera vez que nos encontramos. Alexander Vargas, a quien también felicito por esta idea, tuvo esta iniciativa hace aproximadamente 4 años. Debo mencionar que en esta ocasión nos honra ser la sede de la segunda oportunidad de encontrarnos en un workshop internacional de la Red de Filosofía de Derecho Privado, un espacio que, como ya han señalado, es una sede para discusión de ideas. Tiene la dinámica de workshop, se planean temas, se discuten papers, se hace retroalimentación y con posterioridad tenemos publicaciones que son de amplia consulta. Este evento, que como ya también hemos mencionado, ha sido organizado por el Centro de Investigación en Filosofía y Derecho en conjunto con el Departamento de Derecho Civil, ha contado con la coordinación del profesor Alexander Vargas Tinoco, profesor del Departamento de Derecho Civil y colaborador del Centro de Investigación en Filosofía y Derecho. La Red de Filosofía del Derecho Privado es pionera y está compuesta por importantes investigadores. Es representada por el profesor Diego Papayanis en representación de la Universidad de Girona y por el profesor Esteban Pereira en representación de la Universidad Adolfo Ibáñez. El profesor Alexander Vargas representa el grupo de profesores que trabajan en Derecho Civil y en Filosofía del Derecho Privado por la Universidad Externado de Colombia. Esta red como espacio académico y de reflexión se ha consolidado durante ya más de 4 años. El evento que se materializa hace justo 4 años venía recogiendo las ideas y el trabajo de estos profesores que hemos mencionado y la Universidad Externado de Colombia decide sumarse a esta red. Una red que realiza un evento cada 2 años, pero que ese evento es consecuencia de la reflexión y del trabajo que se realiza durante todos estos años para consolidar ese espacio de debate, de retroalimentación, de construir ciencia. A este evento y a estos conferencistas le damos las bienvenidas y le damos las gracias por el intercambio de ideas y conocimiento, no solamente para esta disciplina, De allí bebemos todas las fuentes del derecho, toda la ciencia del derecho. Este año adquiere un significado especial la reunión y el que el externado sea sede, ya que estamos celebrando 30 años de existencia del Centro de Investigación en Filosofía y Derecho. Este es uno más de los eventos que estamos realizando para conmemorar ese aniversario de un centro de investigación que, como su nombre lo indica, nos reúne en torno de la ciencia, de las bases de la filosofía del derecho y la teoría jurídica. A todos ustedes queremos darle las gracias por la asistencia y por la participación a los eventos que ya hemos realizado, eventos sobre paternalismo en el derecho y la moral, sobre derecho penal internacional, y queremos invitarlos para que nos sigan acompañando a los demás eventos con los que vamos a seguir celebrando durante el transcurso del año los 30 años del Centro de Investigación. Para finalizar y dar ya el espacio a Alexander Vargas y a las sesiones académicas, no puedo retirarme sin darle las gracias a Alexander por concretar esta idea, por el trabajo que ha realizado, a María Alejandra Díaz por su trabajo y compromiso, y a todos los miembros y el equipo administrativo del Centro de Investigación en Filosofía y Derecho que han hecho posible el que hoy nos reunamos. A usted, señor rector, doctor Hernando Parranieto, a usted, doctora Milagros, por el empeño y por el apoyo a la academia en este momento que en el mundo es un reto realizar este tipo de encuentros de manera física y hacer ciencia. Ustedes también están apostando, y la Universidad Externada de Colombia está apostando a realizar ciencia, y desde ya me alegra pensar en el libro que va a salir fruto de los debates. A todos ustedes, bienvenidos, y deseo unas excelentes discusiones y debates que permitan alimentar todos los artículos y las publicaciones. Muchas gracias.
Thank you, Professor Ruiz. Finally, we will have the words of the coordinator of the Network of Philosophy of Private Law, Professor Alexander Vargas.
Thank you, Alejandra. Just take a few minutes. Welcome, everybody. We are very glad of have you today with us. This workshop, this second international workshop, is the result of a joint effort of the University External de Colombia, University Adolfo Ibáñez of Chile, and University de Girona in Spain. I want to express my gratitude with each person who contributed in the realization of this workshop, specifically to the Professor Hernando Parranieto, who, by the way, is professor also of civil law obligation, and that is not a minor information. Thank you to the director of the Department of Civil Law, Professor Milagros. Thank you very much for your patience and for all your advice in the organization of this workshop. Thank you to Professor Carmen Loisa Ruiz Lopez for your generosity and always put available all the means that was necessary to organize this workshop. Thank you, Alejandra, for your time, Jennifer, organization of this also. First of all, I'm incredibly excited of share this room with people who has written a lot of books and articles on bibliography that I use in my doctoral dissertation and in my academic work. And so that is an honor, a real honor for me, and that it fills me with joy this day. Welcome to Colombia, and secondly, this is more like an advice. I know that we're going to talk about philosophical stuff, and serious stuff, and all that inquiries about private law, digging deep in the subject, but don't forget to enjoy this beautiful country. Don't forget to enjoy your hotel, this city, this great city, your historical center, of the city and this university that embraces you in your thoughts, in your thinking about private law, your opinions, and here is we are gonna we are making this also to make good memories about this workshop. Also, this workshop is about sharing ideas, generate discussions, and why not challenging some of our assumptions about private law. And so I encourage you to present your ideas and to engage in debate with sincere and without any fear to political correctness. I think that is the good attitude of a philosopher, and to approach the knowledge without fear to be wrong, like a child, and to present the questions and to ask without any fear to what others can say about this subject. And finally, this is an opportunity to connect with people, to collaborate, and to establish links in academic in this area of knowledge. And who knows, maybe from this workshop arise some ground shakers, ideas that change the view of private law and the way we study. And so let's kick off this workshop and see where this conversation takes us. Thank you very much.
Thank you, Professor Alexander. It is my pleasure now. It is my pleasure now to introduce our first speaker, Professor Anita Herz. Start over. Thank you, Professor Alexander. It is my pleasure now to introduce our first speaker, Professor Anita Herz. Professor Bernstein is Juris Doctor by the University of Yale. Currently, she is professor at the Brooklyn Law School in New York. Professor Bernstein is a nationally recognized authority on tort law and feminist jurisprudence, as well as professional responsibility, products liability, and family law. Her awards include the first Fulbright Scholarship in European Union Affairs given to a law professor. As a member of the American Law Institute, she has served as an advisor on two torts restatements, the recently completed one on intentional torts and the in-progress restatement covering remedies. She will be talking about the heart of tort. Professor, you have 30 minutes. Excuse me, Professor.
Professor, it's only 20 minutes. Sorry. Thank you very much, excuse me for my interruption. Before my departure to attend my own duties, I would like to invite our guest professors to visit the university president office to have a cup of coffee and also to share a chocolate bar at any time at the president of this university. Also, I would like to invite you to enjoy our campus, the forest, the gardens, and we are very proud about that. So welcome again. Good luck for this discussion. Thank you very much.
It's open, so
The video camera.
yeah, it's open.
Okay, I'll do my best. Thank you very much for the kind introduction. I know that a lot of work went into this event, and I want to acknowledge all the unseen efforts that made the experience so pleasurable. Thank you to the Alliance of but I'm sorry, I don't know. I can either stay here or sit down.
Yeah.
And I should stay. Okay. I'll go. The first speaker is the batch of brownies that you throw out when it burns. So I'll do what I can. I wanted to express my appreciation for the invitation to join the second international workshop of the Network of Philosophy of Private Law, the Alliance of the University of Girona in Spain, the Adolfo Ibáñez in Chile, and especially here at in Colombia, have put together an exciting presentation. I have called this talk "The Heart of Tort" as a kind of placeholder name. I may not stay with it. What I would like to do is talk about two papers of mine that were previously published a couple of years ago. I'll give a presentation on each, not as long, I guess, as it would be if they were isolated. And then at the end of my half hour, talk about the possibilities of a new paper that takes into account the ancestry of the other two. The metaphor I've used is the children and families, they tend to look very different to their parents, but outsiders see resemblance. So if you think of what I've done as a parental effort, I think, well, the first paper is an angry feminist lament that presents private law. And the second paper thinks it's all cool and logical and calm, and it would never dream of getting, having any feelings or being emotional. And I suspect that this distinction is overdrawn. There probably are commonalities between the two papers that perhaps you can hear when I talk about their content right now in these remarks. The first paper is called "Private Law as Unjust Enrichment," and it argues that the premises and ideas of private law necessarily work out to leave women in some respects worse off and to advantage men. So I see a kind of zero-sum a struggle. Guadalupe Martinez has talked about the role of the initiator, the complainer, as an actor in private law. And I'm interested in this idea. Diego Javianes has written about the social subordination. I think these are two kind of cousins, to continue the family member here in the room, ideas that are present in other people's works, I think overlap with mine. Private law will not happen, the apparatus will not be turned on, the machinery will not work unless somebody stands up and says, I am aggrieved and I want what I want and I demand what I'm entitled to. And then in response, the accused person, the defendant, digs in and says, I want what I want. You can't have what you want. And on the first page, I'll just skim a bit of it out, a couple of roles or ideology, identities, I guess I would say, that the private law player must be. Private law player, the person who enters the private law system, demands attention, says, this is not just my problem, it's your problem, it's everybody's problem. Listen to what I have to say. It's not only personal. And the attitude, if it appears exaggerated or not in proportion to the entitlement of the speaker, may seem selfish or arrogant if we don't like the push. The claim of a private law participant is also on an advocate demanding the loyalty and attention of a lawyer. That is not entirely related to the amount of money paid or to the amount of talent that lawyer has. The private law player defends boundaries. It says you crossed a line. This is an idea of Arthur Rich. I think the idea of being pushed around or harmed by the interference of another, and all of this content, this stance that is spoken by the private law litigant is pretty aggressive. You can't just get there by receiving government welfare benefits. Nothing is handed to you. And lastly, this person has failed to cooperate and negotiate. The fact that we know about him or her in decisional law or reported episodes of litigation means that that person did not swallow, did not suck it up, did not endure passively and patiently, but refused to yield and is on the attention of a judge. From there, I think that the background that we as adults bring to our entitlements to complain about an injury or to resist an accusation by another is influenced by where we come from. And here I know I'm outside of my home country. This is the problem. I'm rereading these papers for this workshop. I thought, you're a little parochial American much. I'm not entirely universal theorist as maybe should be as a speaker here. So some of what I have to say is about the United States. I do think that the subordination of girls and women is not peculiar to the United States, and that similar antecedents in upbringing happen to girls and women around the world. And so I just reviewed the evidence for different treatment of babies, even regarded as boys or girls when they're young. When you enter the toddler age, being 3 or 4, you start having mass attainment marketed to you. That also sends out messages of acceptance and subordination and passivity for female people, and being an initiator and a go-getter that practical honesty will rely on later. Those are traits that are conveyed and encouraged in men. In schools that have been studied in the United States, I don't know the evidence from outside of my own country, but observations show that teachers interact differently with boys than girls, and sometimes in a harsher way. Sometimes boys are punished more than girls, but what unites the treatment of these two genders in the classroom is a kind of deference and not deference, I shouldn't put it that way. The teacher will perceive as if what the boy is doing is important, make his punishments even more public and scandalous than the punishments of girls. Parents, at least in the United States, give their boys more money than girls. The allowances, that's the parental stipends to children are about twice as high for boys as girls. I know in my country, parents will bribe or pay their sons to take showers and not do that for their girls. The chores that girls do are paid less. And this, I think, sets a template of expecting to be underpaid when one becomes a worker in the labor market. I think this is true around the world, that for most of the time, most places, female workers are paid less than male ones. So being a private law litigant, this disadvantage means that one is less intimidating, one can't buy the most aggressive lawyers. When one is offered a settlement, one might be poorer and need to take a cheaper one. And so the financial disadvantage that derives from being poorer makes an individual a weaker litigant. The history mercifully winds down. I don't go on much longer after that. After being underpaid at work, our paradigmatic female person goes home to an environment where it's likely in her own household to be less entitled, less empowered to assert herself. The majority of women around the world, and in my country too, have at least one baby, one child before they die. Even larger majority of women are in heterosexual relationships at some point, including marriages. And these occasions, as you probably have heard from other people, are locuses of subordination on the whole. I wrote the hashtag not all women in the paper, so maybe I need to say that these generalizations are very crude, and there are many exceptions. I don't want to discount the hardships of the gender that I regard as advantage, but with respect to private law, when one must proceed with a sense of righteous indignation, entitlement, and refusal to yield, I think that the background of being female is a source of disadvantage. And what that means is that the law, especially in a common law like mine, but also outside in other legal systems that work in a more civilian framework, the law is shaped and influenced by male inputs more than that of their female counterparts. When Diego Papianes writes about subordination, his focus is on wealth and poverty, which is, I think, extremely important. And I regard my piece as a kind of companion with providing another axis for locus of subordination. I think that what happens is definition of unjust enrichment. The following things must be present for unjust enrichment to exist. First, an enrichment. Second, an impoverishment. That means a lessening of wealth. Third, a connection between the enrichment and the impoverishment. Fourth, the absence of a justification for the enrichment and the impoverishment. And fifth, an absence of a remedy provided at law. For the last two, I don't think there's a good justification for the inferior position of women in the private law. And I think that not only is there no remedy at law, but law is actually a source of worsening. It's a problem. Private law intensifies and makes stronger the disadvantage that burdens women as participants in a system that demands their initiative. So that's the first paper. And now I want to move to the second one, which is, in my eyes and in my perception, is a very different one. But just to sort of tell you where I think I want to go with this, when I talk about the private law unjust enrichment thesis to audiences, a comment that I've heard in response in the question and answer period is, how can we help? Or do you have anything constructive or positive to suggest? And it's a sort of softball friendly question. And I never have an answer because I'm just ranting, I'm angry, but I don't feel consciously angry, but this is an expression of a grievance, and I don't purport to have a solution. I wonder whether some variation on formalism, where the reformer or the progressive-minded individual who wants to change the state of affairs might look to something that appears either neutral in the sense of not being overtly partisan for one person, or of general interest. It might be the beginnings of a solution. Claims for justice usually try to enlist the conscience of the person talked to and to ask, how would you feel? Is this something that you can relate to? Does my pain or my disadvantage that I'm complaining about strike you as being not only about what I want, but of what others might want as well? And so this is a piece called Q, what is toward a categorical, or Q and A is short for a question and answer. I guess the Q part would be more recognizable if English is your second language. So it's the question, what is toward, and the answer is categorical hurt. Several people in this room have thought about what tort law is, what its nature is, what it's about, and generalize. I think the author's book, Private Laws, is an attempt to speak about all of tort law and make generalizations about it that apply to different claims, different causes of action, and different results. All of them can be integrated. I find that ambition exciting, and I chose a narrower path here because I really was asked, what do you think tort law is? People had to explain its essence or its nature. What would you say? I have a junior colleague at my school who said, what is with you towards people? You're just so obsessed with your identity and who you are. And other fields don't do that. No, I remember what is property, what is contract. It's just, at the moment, there seems to be a lot of noise and buzz around the essential nature of tort. And whether this is of interest to you or not, I don't know, but it's certainly a common pattern among people who work in my subject area. So I think we'll be hearing a lot today about the line between private and public, whether private law is entirely or narrowly private, what it means for the law of torts or any other fields to have a foot in both, to care about the individual grievance that frames private law, and the collective interest that's of interest to public law. And I kind of have an echo of that here in this answer to the question, with the A and Q&A's categorical hurt. And I do not wish to go down the wrongs route that many people like. I don't want to say torts about wrong, because I want to include the causes of action or claims that appear contrary to wrongness, notably strict liability. And so categorical refers to the public half of the origin. It's about what is of collective interest. Working with the idea of con. I know I'm a con amateur in this room compared to other people, so my rendering of con would be rather shallow, but the Kant's suggestion about figuring out what to do as a matter of ethics is to ask yourself whether what you're planning, that it can be generalized into some kind of universal maxim. So a claim for everybody, inclusiveness, all persons in the community being equally in range of the idea is covered in categorical. And hurt is more of the private side. It's the pain that an individual litigant feels. And I think even when a party to a tort claim is a corporation or a business, it is still protested what it regards as a hurt. Categorical for the matter of general interest, hurt for the claim of the individual. The evidence for my construction, I guess we're trying to find reasons to get people to agree that it is correct to say towards about categorical hurt. The doctrines of standing and causation are ones that rely on and expect an assertion of having been harmed by the individual. It is possible from the outside to design reckonings and accountings and constraints that don't depend on the complaint, and those in that alternative scenario, the law would not rely on people protesting an injury, but instead would try to figure it out, identify problems some other way, and the legislature with its large budgets and research capacity would be the example of that. But even a TIPS hotline, call anonymously to report some kind of misbehavior, that could be another way to get the information needed to figure out problems and to come up with solutions. But tort law is on an individual who complains that a wrong to have suffered from it, or at least be at risk of suffering in case of seeking an injunction. So you'll be tossed out of court for failure to state a claim if you can't associate the wrong that you're objecting to, the conduct you're objecting to as a source of harm for you. Now, in my country, we use juries for tort disputes, not true in most other places around the world. And so here I'm being parochial and American in a bad way, because I know that the layperson fact finder is not the norm for this cause of action category law around the world. Even though the large majority of disputes don't go to a jury in my country, the pleadings and the argumentation and the advocacy of the lawyer is all oriented toward a lay fact finder versus a human being rather than an expert in the law to decide yes or no on liability. And I find evidence for this outside the United States as well. Reasoning with another person, asking that person to side with you and against somebody else or something else is a claim on feeling and emotion, as well as on the application of a legal theory. I did a paper once on asbestos liability. Supposing years ago, and I found reasons to think that judges were feeling the pain of asbestos claimants, and that even defense lawyers were moved by the suffering and fought less hard, yielded or gentler in their resistance. So I think tort is central. I think that hurt is central. Excuse me, to tort, and that it is more than a formally check the box of complying with some kind of technical requirement. As for the categorical kind, I think I'm running low on time, so I'll end up talking even faster, which is sometimes hard to do. A categorical is the Kantian antecedent of and the kind of public law counterpart of a tort. And I want to sort of comment, maybe this is a language issue that doesn't translate to Spanish, but categorical is sort of an ironic or self-contradictory term. In English, we say flammable and inflammable, the opposite word, they mean the same thing. Apprehend and apprehension mean both loss and capture. And so a categorical imperative is one that applies to everyone, but categories are precise demarcations or subdivisions of the law. So I would say it can be both particular and general. But the answer is yes, it can, and Kant was quite clear that, I know only a little bit of German from writing, I referred in the paper, that a classification or a concept can be both aggregative, put everything together, and also insisting on subdivisions and subcategories within that a larger categorical. And tort, I think because this, again, my layperson version of Kant, tort, I think, is especially good as an illustration of categorical. Even though one might think public law would be the better category, the criminal penalties assigned by scheme, distribution plans in tax law. But tort tells the individual, figure it out, gaze at yourself, because, and again, this is the United States tort law more than worldwide tort law, but even civilian tort law, it speaks in generalities. And so the reflection that Kant urged on his readers to think about the larger relevance and impact of their ideas, that's what tort demands as well. We're trying to figure out how to use reasonable care or how to avoid crossing the boundary recognized in an intentional tort. You don't have a very precise script to go by. You have to use your own reflection and thought. And so in criminal law, with the other sorts of sanctions and penalties, it asks less, I think, of the individual. One who knows more about this than I, but I think the criminal law is more precisely prescriptive than tort law. Yet tort law is prescriptive. It does tell people that they'll pay for the harm they cause if they do it. Now, those are my arguments in favor for a categorical constituent to tort, and also hurt involving the pain of an individual. Now, with only one more minute, I don't have the answer to the question how do the two papers fit together. I'd be very thankful if you can find me online or here in Bogota, and if you have suggestions on how these two papers seem to have commonality, I'd be very grateful to hear about that. The preliminary thought on which I'll conclude is that the claim of injustice that I am asserting in the first paper is one that calls on people who are not affected by this detriment to sympathize and engage. And so I'll be interested in Diego's ideas about what to do about the problem of social subordination, try to ride along with his prescriptions and suggestions. Make it possible for other people to understand the wrong or the hurt that you are experiencing. That seems to be the only way forward to get the kind of change that I would like to see. Thank you.
Thank you, Professor Bernstein. Especially for, of course, for your wonderful lecture. Now we will open the floor for questions from the speakers and the public. Do we have any questions for Professor Bernstein? Maybe you can raise your hand and I will get a mic. Professor Bernstein. Thank you.
Hey, thank you for the presentation. I enjoyed it a lot. I enjoyed the first paper. I was not able to read the second one. I didn't have the time, but I have two questions or two comments maybe to start the discussion about it. The first is about the idea that litigation is aggressive, and also that in litigation all the deficits or all the inequalities that are pervasive between men and women in our societies are reflected in litigation. But at the same time, I read some papers some time ago about poetic justice in cases where victims of sex trafficking were able to hold the wrongdoers accountable. And this had a very strong expressive meaning, or was important that the person that was treated as property now were able in a civilized process to demand from the others to do something about what they have done. So I think that at the same time, it's not all negative. It's true what you say, I think, but there is another side that might be positive because allows for some I don't know. But also an opportunity to balance things between men and women. The first. The second is just a comment about the idea that there is what is your positive pieces about this? How can we solve the problems of unjust enrichment? I'm wondering what you think about judging with gender perspective. I read a case in Argentina many years ago, more than 23 years ago, I published a piece. And it was the case in which an older woman got in love with a younger man. And this younger man led her to celebrate some transactions, conversion transactions, that were detrimental to her. And after the man won all that he wanted to win in that relationship, they split. So the woman sued him under something similar than as unconscionability. She argued that that was a case of unconscionability because she was in love, she was vulnerable in that situation, and the judges say it's completely understandable that in that situation, the person that was lonely, that was feeling alone, that was in need of some affection, that would celebrate some contracts that were not good to her, and she was. But if you read the unconscionability provision in the civil code, it doesn't fit exactly in the situation because she was not an expert. She knew about business. She was not someone with some weakness, intellectual weakness, or she was not in necessity in the traditional meaning of necessity. But now I remember that case, and I say maybe from a gender perspective, we should interpret that it was a case of unconscionability, and in this sense, there are some remedies that can be implemented that give us better results than we normally have. Okay, thank you.
Thank you. Those very, very, very interesting remarks and questions. I am gratified to invite people in the room. I know we're streaming and not everyone has this pink sheet of paper that I handed out. But what I have on the second side of it is responsive to some of what you said, Diego. So with respect to your first remark or question about litigation enlisting aggressiveness, demanding a lot by way of assertion on the part of the individual, I understand you to be saying that yes, that is a burden, maybe a threshold or a difficult hurdle to overcome, but the rewards, the satisfaction once having prevailed, would make the struggle worth having waged. And so I wrote on the back of this would have been the third slide. I had a slideshow. I say, assuming we keep private law. So that's kind of what you're saying as well. You don't want, it's the rhyme in American slang or the expression is mend it, don't end it. I don't know, translates it into Spanish, but repair private law rather than abolish it. And one response that be consistent with what you're saying about the sex trafficking plaintiffs or complainants is to support or encourage or underwrite this assertion when make it easier to be a complainer, and that could involve a multiplicity of influence and investments, but could be cash money, it could be support. They're trying to encourage a positive attitude rather than a negative one against or toward people who complain. But yes, I would prefer to see a world where private law was accessible rather than abolish private law and impose from above something different. I think your example about the Argentine case where you suggested a gender perspective on unconscionability might yield a different result. I read the American data on women as judges, and the consensus seems to be that they judge the same as men, and the reason to want more women judges or encourage the appointment or election, unfortunately, in my country, of female judges is for expression and visibility rather than to change substantive outcomes of cases. So I see there's some women in the room, and I wonder, having listened to Diego's story, whether you'd like to change unconscionability to allow a woman to get out of a contract saying, I'm weak, I'm in love, I'm old, he's young, I couldn't empower myself, I want to defeat this contract, tear it up, because I'm not confident. So I'm recoiling a little bit. I did not. There were, and I won't call on anybody, and then to the men as well. Would it be a better treatment of unconscionability to create to widen it to include the weakness of social vulnerability in the age factor in heterosexual relations? I think probably I would rather not change unconscionability along the lines to suggest I don't think women judges would go for it either, but that's just a guess based on what I've read. However, and why I wanted to mention the backside of the sheet of paper, I think you put your finger on something that's important, which is about the classification of people as, for whatever reason, not fully empowered to assert their own interests. And that's what the law calls disability. So children can't be aggressive litigants asserting their own claim, and people with adults with disability also can't. And maybe this is a conversation about whether the older woman in our case was in some sense disabled. And if we have a more careful idea of who can't be expected to assert herself, and then think about other people who are not covered by that disability and try to find out why they're not maybe not speaking up as much as they should. I think that would be a constructive application of your idea, and one that I would feel happier about than call that contract unconscionable. Thank you.
Thank you. I think one of the women wants to answer, so
Professor,
Not,
say something else, right?
Thank you. Thank you. Thank you. I enjoyed reading your papers, both of them. And I could go through one of them. And actually, when I was reading them, I was trying to find the connections that all these
Yes.
But first, I would like to follow up on what your discussion, your exchange with Gregor, on the idea of the private actor. I see also an idea of private actor that is not so much into the aggressive line, but more on the idea of voice, on the idea of construction of meaning. And but we can maybe discuss it. I will I presented a bit on that, but also I think there are some distinctions to make it more positive view of the private actor. But my main point is on your idea. From your paper, you mentioned that aggregation is a kind of the glue that allows you to break the polarizing narrative between law and economics and others approaches to law. And I was very interested in that because in general, I sympathize with approaches to try to close the gap and have a conversation that is not as polarizing as that narrative. And so I was wondering whether this idea of aggregation actually is the one that will help you to move towards the idea of universality that actually you are trying to argue for. Because I think this is the biggest connection I see. And then I wanted to suggest, I don't know if you check Feynman that works on universal vulnerability. And actually what she's proposing is a concept of vulnerability that is not only layered, but that is universal. And it has been picked up in the consumer context. Again, trying to break the idea of empowerment, and the idea of like weakness or representation of disadvantage of the party, but more of the idea of the vulnerability that is structural, that is universal, and that it's better addressed not in terms of categories or exceptions, but in terms of universalities that we can pick up.
So I wanted to hear a little more on whether you see a connection between these two elements and whether this is the direction and you would like to go or whether this is helpful. I can then share this by learning if you're interested.
Thank you, Olivia. It's extremely interesting. I appreciate your careful parsing or more granular look at what I said about the about private law demanding aggression. To say what it demands in voice, or and similar thing, not only demand but reward. But one can characterize the encouragements of private law as one that would kind of welcome and encourage expression rather than necessarily demanding selfishness or pushiness in the sense of wishing to elbow the other person in the eye. Now, this is a theme in your writing in general, the struggle between the lumping and the splitting, in particular, and the general. I think anyone with an interest in private law has some kind of intellectual orientation around that problem. Which generalizations are meaningful enough to be true, which are destructively unifying in the sense that they're putting together that which ought to remain separate. As for Martha Feynman, she's my colleague at Emory, and I worked to hire her in 2003. So, and her vulnerability project is one that I've known about for a while. I think she's right. Feynman, is right, and to say that we're all vulnerable. The idea that Feynman talking about her own experiences as a wife and mother, and she has 4 children. So from an early stage in her adult life, she was made aware of the problem of a child, and I think children are a problem to libertarian thought and all kinds of ideal type generalizations about what people are and how they can be used or rather than used. Yes, we're all vulnerable. We're all going to die. Or if we're not disabled, we will be soon. We will need help. My mother moved to a nursing home at age 96, and I'm watching this book, which is the toughest, most vital person I knew. And so I think this is true. The problem, though, I don't know whether if you're on the advantage side of the gender line, you can think that this will be me. Knowing that your condition is likely to be lifelong and recognized forever. So I guess it's an open question, but whether the vulnerability piece would solve the problem. Definitely worth thinking about.
Thank you, Professor. Of course. Professors.
So thank you for this, Anita. And you asked for suggestions about how to combine them, and I'm not sure this is a suggestion about how to combine so much as an observation about something they have in common that might be relevant to your efforts to combine them, which is that they seem both papers are almost exclusively plaintiff focused. On the one hand, and this is in fact is what raises Diego's example so forcefully, because the first paper is about the plaintiff asserting themselves, and the second paper is about the plaintiff suffering something. But of course, when there is a tort, there's always a transaction that something happened to the plaintiff, it's that somebody did it. And I think the thing that makes Diego's example so interesting, flip it around, flip the gender roles around, and I'm not saying I would be in any way happy with this, but my prediction would be that a court would immediately describe the older woman as manipulative because of gendered stereotypes, because of pictures of, as it were, standing on their rights too aggressively. And so I think that's just something to think about in thinking through how they fit together. So too with categorical hurt. I know you say you don't want wrong, you want only hurt. But of course, a hurt is something that happens to someone, and a wrong is something that someone else does to that person. And obviously, we can have a longer conversation about how to think about strict liability in relation to wrongdoing, and we have to keep right away from that conversation to distract us. But the basic thought, it seems to me, is that if you think about it more transactionally, it may be that you'll get a clearer picture. Let me just give you one illustration. This is something that came to mind when I was reading the first paper. My colleague Mayo Moran, in the book Rethinking the Person, talks about all of the child allurement cases. And of course, most of them are cases where the child was found, where the legal issue is whether the child was contributorily negligent with respect to the injury that they suffer. And she goes through all of the cases in England, Canada, Australia, and New Zealand. And it turns out that girls are expected to be more careful than boys. And now that's, but of course, in the small number of cases where there are child defendants, girls are also expected to be more careful than boys. But that's the same phenomenon that you're interested in. And so it seems to me that just as a way of thinking through your problem of how to combine them, you might want to look at defendants and see how each of those issues manifests.
Thank you. I have a bit of biographical reason to think that you're right, that I am focusing in a lopsided, asymmetrical way too much on the plaintiff. There is indeed always a defendant, and the defendant will always be looked at as a person and have a story told, and then externally the interpretation of the defendant's behavior asked about what that person thought, what he or she did, and what responsibilities flow from that person's choices or wrongs. So what's happened to me on this issue is I have invented my own course. It exists elsewhere in the US, but it's not very common. It's legal malpractice. So it's about the subset of complaining or injury that relates to lawyers doing wrong. And it's a kind of parallel to a mandatory course of legal ethics that we have in US law schools. But instead of sanctions being imposed from the bar or the profession, they're imposed through private law. It's mostly negligence law, but not, but it also involves breach of fiduciary duty, fraud, and a few other causes of action. And I'm writing a course description for the next summer semester, which starts on May 28th. And I say, I have to print it down and get my, and what you're saying is very helpful to it. That most of your legal education has been from either the point of view of an aggrieved person, the private one. You breached my contract, you crossed into my land, if you were negligent towards me, the way the story is scripted and framed by the complaint, or it's public law where the government decides taxation or criminal penalties. I see here, even though this is a plaintiff focused course and that it's private law, we have to think about it from the defendant's point of view, because almost nobody practices plaintiff side legal malpractice litigation. But in my country, stay in the private sector or earn your living through fees, you will be sued for legal malpractice. So you and I have to grab our heads around the idea that the defendant is the star of this show, because you need to relate to the defendant category much more than the plaintiff one, or at least equally, I guess. And it's so alien, so contrary to my cast of mind, part of many years, I guess, of being entrenched in the same pattern. But I think it's a very pertinent reminder for my summer teaching as well as my writing.
Thank you for this, Anita. I had a question that I thought was out of the blue, but I think I'm going to be a little closer to you. I teach both the professional responsibility class and it makes me think that the lawyer is indispensable thinking about how you might make progress in this problem, because in the standard professional responsibility literature, the starting critique, and there are counter punches, but the starting critique has a lot to it, of lawyers' personal injury cases that they dominate claims. So that might be an original assertion on the part of the client, which is showing up at the lawyer's office. But the client is both disabled in a fundamental way, like they don't actually know what's legally relevant, because they don't know how the law constructs the hurt, so to say, right. To speak. So the lawyer can very easily manipulate them, but they also need the lawyer's assistance in order to understand that what most bothers them may not be the way that they can articulate their claim successfully. And then the other general view is that the lawyer reduces the client's complaint to its dollar value and then simply manages the process that's driven towards settlement in order to maximize the lawyer's return, because their maximal return is very clearly not too much time relative to payout. The whole thing's extremely disempowering for the client. So I'm thinking that certain things here aren't going to change in the sense that even if clients become more assertive in willing to articulate their hurts, they aren't going to know what their hurts are, because law is unlikely to get less complex. So I was to say, doesn't it seem right to you to think we should think of this as how do we think about how the role of the lawyer really ought to be quite different from the way we standardly imagine it to be in the personal injury case? That's the place where you might make progress on this.
Yes, I agree wholeheartedly, and thank you for that. I would be interested in the non-US, maybe majority of them, in the room, if they wanted to speak to Greg or me, or afterwards in some context. I'd be grateful to know that what Greg's story about the role of the lawyer, it makes sense where you live, and in the legal system, you know, from being part of it. Yes, tort law in the United States is very, I think you must be right. Lawyer driven, lawyer managed. As you say, you don't even know without the law whether you're suffering is of the type that the law will care about. The rhyming old title of an article, the naming, blaming, claiming. So many cognitive steps are necessary to realize that one has a cause of action. That the lawyer is an indispensable actor. Lawyers are also a relatively discrete category. My country is large, more than 300 million people, but the number of practicing lawyers, what is it, about 800,000, maybe, the relatively manageable group. Maybe if I'm a reformer, if I want to be in any way an activist type of scholar, that would be the audience that I would want to talk to. Thank you.
Thank you, Professor Amida. I just have a question, and it's about the idea of suffering. And when you say suffering as a part of the idea of thought, are you thinking in human beings or in physical suffering, pain, something like that? Because I understood something like it would be like empathy as human beings to see the suffering of the others in your paper. But I think in this category that we have here in civil law, the moral persons, yeah, and that is a private corporation. So
I'm sorry, I didn't hear moral persons.
Moral
persons, yes, right, yes.
Is a person who is different from natural person, human beings. Yeah, and when I think in this moral person, I don't see the suffering like experience, physical experience or human experience.
I'm sorry, Alpha. I want to follow what you're saying. It seems extremely interesting, but I worry that I don't understand it accurately. A moral person is a substitute for a natural, a counterpart to a natural person. So does that mean that natural persons are not moral persons?
Yeah.
Okay, so yeah. It'll be only artificial, never anything but artificial. Okay, that's right. So it may seem a little bit confusing, I guess, because I want everybody to be a moral person, but it applies only to entities, right? Yeah, not human entities, right? Yes. Okay, I'm sorry, that my interpretation.
So how suffering beats? Yeah. This kind of person that doesn't suffer.
Yeah. You know, I hear parochial again. I'm of a generation that was influenced by what is called in the US the tort reform movement. So the tort reform movement is a right-wing conservative shift to regard litigation as bad and needed being discouraged and ruinous for business. I don't hear this much in the United States, but I remember advocacy contending that the United States is disadvantaged in the international trade market because its liabilities so unfair and so trying to sell automobiles as against a Japanese manufacturer. The US has one hand time at its back because it's paying out all this toward overhead, settlements and insurance, whereas a Japanese business doesn't have that expense. I think this is sort of an engagement of sympathy or empathy on behalf of non-human recipients of that attention that was somewhat successful, and maybe part of the problem in the US that in my opinion anyway, we're a very victim blaming culture, the comparative negligence or plaintiff's fault that we just heard about can be very strict and condemnatory on people who complain as well. So maybe the tort reform movement conveniently kind of hitched the ride along a sentiment that was already there regarding people who object to behavior, claiming that they were hurt as being trustworthy, greedy, unreliable, and the like. But for whatever reason, I do think that there's been some progress, at least in my country, maybe progress is not the right word, some gains of the efforts to engage and apply sympathy toward non-human actors, the moral actor category that you identified. If it is true, but it must be the case that feeling and sentiment are thinner and weaker for a non-human agent than a person. I just would not be ready to agree that the category of empathy or sympathy or fellow feeling, as I once called it, borrowing from Adam Smith, is one that never extends to those moral actors. I think it can.
Thank you. Are there any more questions? Okay, thank you, Professor.
Thank you. Oh, thank you.
Thank you, Professor Bernstein. I'm not sure, are you hearing me correctly? Thank you. Allow me to introduce our second expositor. Conference is from Professor Gregory King. Professor Keating. I'll wait. Maybe you can sit here while I introduce you. Thank you. Professor Keating is graduated summa cum laude from Amherst College, earned an MA and PhD in political philosophy from Princeton University, and graduated magna cum laude from Harvard Law School. Professor Keating is an editor of Torts Casebook and writes on torts, professional responsibility, and legal theory. He has published articles on the morality of reasonable risk imposition and the law of negligence. Professor Keating will be talking about irreparable injury and the incompleteness of tort. Your time, Professor, you have 30 minutes.
Thank you.
You can see.
Let me try this. I think I'll wander around slightly and peripatetic or something. Thank you very much for the introduction, for having me here. So this is a piece of a book I wrote, really carved out, and I'm interested in general, but I'm also interested in your thoughts on it. If you happen to solve a problem that I draw a complete dead end on at the moment, which is one of the fundamental things here is about asymmetries, and I'm starting to think about autonomous vehicles. It's clear that people have asymmetric views about the amount of safety that they want from autonomous vehicles. And the classic question that always comes up is that rational or irrational? anyway, let me talk about this. So this particular paper has, I think, two dominant themes. One is that tort law is intrinsically incomplete. And here I'm sort of, I think of myself as pushing back in some sense against two strands of thought that are very prominent in North America. One is corrective justice theory, and another is law and economics. And the argument that it's intrinsically incomplete begins from the idea that the default tort remedy is reparation for harm done. And the problem is that reparation is rarely fully adequate. Reparation, there's a certain sense, but I think this may not matter, that you might say, well, reparation is never adequate because you lose time and you can never get time back. I remember long ago having a conversation with an economist colleague of mine about what is the ultimate scarce thing? And then he said, I think it's time. And because of mortality. So true enough. So you consume time in any kind of litigation, and therefore you can never fully repair the effect of any wrong that needs to be undone. But that may be so true of everything that it's not what cuts ice here. The fundamental idea in terms of what cuts ice is there's certain kinds of damage. And think of it as damage that counts as tortious to fungible commercial property. So I use the dock in Vincent P. Erie as my example here. And if you destroy the dock or damage the dock, you can either repair the dock and it's good as new, or if you destroy it completely, it's just commercial. Dollars cash out all the value that it has. And in that sense, reparation can do what it is that reparation claims to do in the standard rhetoric. I should say the standard rhetoric, interestingly, includes different formulations, but a standard formulation would be to put the plaintiff in as good a position they would have been as if this hadn't happened. Or an economist would put it back on an indifference curve where they were before this happened. And that's true with respect to commercial property. It's not true with respect to the stuff that we actually care about, which is physical injury. Physical harm, which does include property damage, but think of it as damage to persons. The more serious it is, the more irreparable it is. And this isn't to say that damages can't do a great deal for you, but what they do for you is really to enable you to build a new kind of life. So that even if you're thinking of property, but it's not property that's purely fungible, it's property invested with personality. So you're thinking of something like your own home. If your home burns to the ground, insurance money damages can do a lot for you. But what they'll do for you is to enable you to construct a new life, not to put you back on the narrative arc it would have been, but for the loss of your home. And that becomes truer and truer when we think of physical harm. For example, if something inflicts a severe disability on you, you won't be brought back if you lose both your legs to the condition that you were in before you lost your legs. You'll be put in a position where you can build a new life, which may enable you to overcome that impairment fully or not, but it won't be putting you back in the position that you were in. Well, the limiting case of this is death, and there's no putting anyone who's died back on the indifference curve they were in before they were dead. And this has always been recognized in tort law because tort has never recognized damages awarded to the victim of wrongful death for the value to the victim of the life that they have lost. And if you look at the history of wrongful death damages, there are no wrongful death damages at all in the 19th century. There's been massive statutory development since. In North America, it's two different statutes, a survival statute and a wrongful death statute. I talked briefly about what they are in the paper. The key point for our purposes here is it's very telling that they're statutory because tort reached the limits of its powers of repair when it confronted death and said, well, what are we going to do about that? And statutes come along and in various ways attempt to address it. But even statutory mechanisms which reach to the point of recovery for what the victim would have had if they survived the injury for a certain amount of time and hadn't died, period of time that they were alive, and they reached to the harm to other people, the relational harm that people suffer from wrongful death, those who were dependent financially or emotionally upon the killed person. But it doesn't reach, except in 2 or 3 jurisdictions, to there's a kind of damage called loss of enjoyment of life damages, and the overwhelmingly majority view, like 47 states, is you have to actually be alive to be suffering loss of enjoyment of life damages. We don't have to award damages for that to someone who's died. And what that means is 2 ways of thinking about it. I think from the point of view of the basic theories of tort, tort can't repair the harm that we are most concerned to avoid, harm that's most severe to us. And that's a difficulty if you think of tort as a corrective justice system preoccupied with reparation. But if you think of it from an economic point of view, tort's a pricing mechanism. Tort is a kind of shadow market in which what you're trying to do with damage awards is to value the harm in such a way that it's registered properly by rational actors, so that rational actors will not injure and kill other people when it would be inefficient to do so, because you would be creating, you wouldn't be maximizing value really cashed out as wealth. But if you cannot, the system doesn't even attempt to price the worst harm that people can suffer, then the pricing mechanism is intrinsically incomplete. And so the other main theme in the chapter is there is a solution to this, and it's regulation. And that it's regulation and not, although these things, I don't mean to say they don't do something, but there are 2 other places that the literature and I think actually the law goes. One is towards the expressive role of damages, which I'm not against. It's very important, but the expressive role of damages has limits. It doesn't even attempt to claim it can repair this harm. It does very interesting things, but doesn't really solve this. And the other is to think of punitive damages. And punitive damages can do something here, but punitive damages are really calibrated to a different problem, because the problem of punitive damages is really the question of whether tort law should respond differently to various kinds of egregious wrongdoing and what counts as egregious wrongdoing. It isn't the severity of the harm. It's the fundamental concern of punitive damages. It's quite possible to inflict devastating injury and even death with trivially careless conduct, given the kind of powers of the technology that we all have at our disposal, even in ordinary cars. So the problem there is that whatever can be done has to be done ex ante, because it can't be done ex post. And the solutions that I think are in the legal system in the United States, I suspect that there are other kinds of norms that I simply don't know in other legal systems. But the 2 I focus on are the safety and feasibility norms that you find in American federal statutory risk regulation. The safety norm is prominent in American federal environmental regulation. And it essentially says that certain kinds of, and they're usually pollutants or toxins, should be reduced to what's called a safe level. And a safe level is not an absolutely safe level. It's a kind of what we think of as the irreducibly minimum we can get, given that life is inherently risky, because activity just does produce certain amounts of harm or injury. And there's a tendency in this literature, perhaps not entirely adequately, to focus on 1 in a million risk of something as a kind of magic number. But the idea is that kind of risk is a risk that you would ordinarily disregard because there's so many things that can kill you. That really counts as safe. And the feasibility norm is a norm that's found primarily in federal workplace safety regulation. It's the dominant norm for the Occupational Safety and Health Administration. And the feasibility norm says reduce a risk as far as possible, consistent with tolerating the long run flourishing of the activity. So it is a retreat from the safety norm. It applies when you think you have some kind of activity. And the activities, interestingly, that are focused on in the leading early cases articulating it are now things who probably might like to do without, because petroleum is one of them, refining petroleum. But the idea in these cases is you can't really imagine the society we live in functioning without petroleum. But you also cannot make the refinement of petroleum safe to the safety level except by shutting down the activity or crippling. That's not acceptable, therefore you go to the feasibility standard. Now, these standards have been universally criticized by law and economics scholars, and it can seem in the American risk regulation literature that there is no opposition to criticism of them. Cass Sunstein has written 6 of the same books criticizing these standards. And the argument is just a straightforward economic argument. It's irrational. And the reason it's irrational is that on an economic view, rationality is defined by maximizing value as economists conceive it. You should think of tort law and risk regulation as price systems. You should think of everything as pluses and minuses on the same scale of value. Everything is fungible with everything else at some ratio of exchange. Just figure out how much you should put in the way of a price and then trade it off. But never should you adjust the trade-off point not to be the efficient point. It's just irrational. You're preferring less value to more value. And so my argument is, this is certainly true in its own terms, but the terms are eminently contestable, I would say mistaken. Since it's only me and 1,000 economists, I'll say eminently contestable. The reason is that the other way to think about this is not to think about it in terms of economics, which is a sense of descendant of utilitarianism, but to think of it in terms that I would identify broadly with liberal political theory, particularly Rawls or Scanlon, and to think of it here as values as incommensurable and plural, and as the role the state is trying to establish certain kinds of basic conditions for persons to pursue their own lives as they see fit. And one of those conditions, a kind of Rawlsian primary good, not on his list of primary goods, is safety or security. That's something that everyone needs if they're to lead a reasonable, decent, independent life of a normal length. And that stands in an asymmetric relation to ordinary costs. That is, harm and benefit in this framework are asymmetrical, not symmetrical. I think that's actually our ordinary moral intuition, is that harm and benefit are asymmetrical. And the reason for this is that physical integrity has the quality of being very broadly valuable. You need physical integrity for almost all of our normal human life plans, whereas benefits tend to be much more relative to particular life. There are sort of, even extraordinary wealth is good for some people and sometimes bad for many of us in many circumstances. It's true for all kinds of extraordinary talents, whether it's mathematical talent, athletic talent, or anything else. These things tend to be much more particular to life plans. I think you could actually see that in law in 2 basic structural features. Think of the American legal system. The law of torts is robust. The law of autonomous restitution is very constricted. The law of autonomous restitution is restitution not as a remedy, but as a right. And that requires a circumstance where you impose a benefit on somebody, but where we can say, that's not an imposition upon them that they should have been at liberty to choose. In fact, much imposition of benefits looks like harms, because you're taking control of somebody else's will and telling them, yes, the music I'm playing outside your window is wonderful music. You ought to be paying me for it. Circumstances where we regard benefits as unambiguously beneficial and their imposition on someone elicits an obligation to pay for it are very few. And it's because of this asymmetry between harm and benefit and the roles they play in our lives. It's also the case that the American Constitution contains a takings clause requiring the government to pay just compensation when it takes property, but it doesn't contain a benefits clause. And of course, many things that the government does is both harm and benefit. Just a simple example, like a freeway. If you build a freeway, you take property from people through eminent domain to build a freeway, but there are an enormous number of people who benefit because suddenly they have property near the freeway, and we don't attempt to recoup those benefits. So there's this deep asymmetry, and it's not an irrational asymmetry. It's rooted in a different understanding of morality as a matter of the relations among persons, different understanding of the responsibility of the state as establishing the conditions for persons to pursue their own lives. And within that, the harm and benefit are asymmetrical, and it is the logic of their asymmetry that's tracked by, if you line up three different standards in America. The safety standard as the most stringent, then the feasibility standard is next, and cost benefit analysis is third. There's even a place for cost benefit analysis, and it is illustrated by Vincent, which is when you have purely fungible property and its value is simply its commercial value, then the proper level of precaution with respect to that precaution is efficient precaution, because efficient precaution captures the value correctly, and any question of fairness that you have can be dealt with after the fact. If it's unfair to transfer the loss from the owner of the dock to the owner of the ship, well, that fairness can be rectified by the payment of reparation after the fact. That kind of fairness can't be done ex post when we're dealing with irreparable injury. And then if you take those two other standards, what you would think is, in a first best world, the economist equivalent in my world of the efficiency standard would be the safety norm. That is, the ideal social world is a world in which everyone can think they can live a normal lifespan, they won't suffer irreparable injury or premature death at the hands of some wrongful agency or toxic substance or the other things that tort law addresses. And then the feasibility standard is the retreat that we make when an activity is so valuable that we can't give it up. But it's also the nature of the activity that we cannot have it attain the safety. So that's that. And I'm thinking, is that the same asymmetry that underlines people's aversion to autonomous vehicles? Gotten no further than posing the question. I'm shocked you would start.
Hey, I didn't put, I waited to put my hand up, which is progress in private conversation. So thank you so much for this break. We have had a few conversations about some of these issues.
I must be getting less triggering because you didn't put your hand up. But go ahead.
Yeah. So I have what I believe to be a slightly different question, as well as version of the old question. We begin with a slightly different question, which is that in Commonwealth legal systems, the UK, Canada, Australia, New Zealand, Singapore, the standard of care in negligence requires that an act is negligent if it creates more than an infinitesimal risk, which Lord Reed puts in terms of something happening so many times in thousands of years, right? Or once in so many thousands. So one question is whether that wouldn't just solve the problem. If you had the right standard of negligence, then of course you would have the level of safety for everyone against these irreparable injuries. Now, of course, it is true that it would still happen in so many thousands of years. But of course, that's going to happen with your safety standard too. Your safety standard is not going to reduce irreparable harm to zero. It's going to reduce irreparable. So that's the first part of it. But the reason these are not two questions. It's a two-part question. Because if you put it that way, then you're focused on the case in which the creator of the risk must keep the risk within a manageable level. Now, when you go to your discussion of safety and feasibility, it seems to me that although you talk about the asymmetry between harm and benefit, that's not actually the asymmetry to which you are attending. I actually think that you are attending to the asymmetry between the creation of a risk and the amelioration of the risk. Here's why. If you're just concerned about the value of safety, and again, obviously I'm entirely with you against the economists on this, then it seems to me that you would not have the feature that either the law of tort has or that the safety standard has, which is it puts the burden only on the creator of the risk. It doesn't put the burden on third parties. But if life is so valuable and incommensurable, there's a question if you're putting it in the vocabulary of value and the protection of the thing that is irreplaceable. Again, I agree, I think it's irreplaceable. Why there isn't the same kind of duty to protect people against risks posed by others or posed by nature. Because if we're talking about what people would agree to behind a Rawlsian veil of ignorance or a Stanwellian contractual co-deliberation, it seems that what they would want, they don't care if they're interested in the conditions of their own agency. They don't care about being protected from each other. They just care about being protected. But that means they would willingly, just as they would forego the advantage of posing risks, it seems they would also willingly accept the burden of protecting people from risks occurring from nature. But that's not just not the way that the law of tort normally operates, but that doesn't seem to be the way in which the safety standard, as you described, operates. So I want to know why we put the burden on the risk creator if we're going to explain it in terms of the impossibility of remedying these harms, given that the cost of preventing these harms could be managed by others.
Right, so I actually think there's more than two questions, but it's all parsed them a bit differently. On the beginning with the negligence law, I find English cases somewhat elusive, and I think that's partly a feature of even in England that common law adjudication doesn't articulate standards the way a regulatory process will. But when you look at the United States and you do have jury adjudication, too little of it, vanishing trial, et cetera, but nonetheless, in its impact on law articulation, you're looking at a black box. So my intuition is that juries do think the way English law thinks, and that English law thinks the way that the safety and feasibility norms think, and that you could see that as the common law expression of the safety and feasibility norms. I think there's less there to work with if you're trying to explain norms, because the law articulation process is develops law less. But in that thing, the fundamental difference is you still face in a common law tort system, a private law tort system, that reparation is the remedy. And when you get irreparable injury, you still face the wrongful death problem. The common law correctly concluded in terms of its own logic, there is no recovery. So the question is, how do you think about the significance of that? There are at least two different ways you can think about that. You can think of it either in the economist terms as no incentive to perform, or you can think of it, I think, sort of in more social contract terms as you have an assurance problem, because it is the prospect of responsibility for the harm that is the assurance that somebody has that other people will honor their obligations, even though self-interest might tempt them not to. So I think you still have, even if you accept that it would be best, and juries tend to think this way, so maybe they do, to interpret the negligence norm as a safety or feasibility norm, depending on what you're confronting. I think you would still think that the common law suffers from this problem of being tied to reparation as its default remedy, and reparation being inadequate the more severe or the more irreparable the injury is. So I think you would still see the regulatory alternative as kind of necessary to complete tort law. Okay, I think there are a lot of things raised by the second question, and one thing that's raised is, like, I give an example here, which I'm a little ambivalent about, but I keep sticking with it. And the example I give is rescues, and rescues drove the statistical, the early and still in some ways the most brilliant, as the literature got routinized, literature in economics on the value of life. Schelling, for example, a life you may save may be your own, found the whole literature. And rescues were the quintessentially irrational human activity because, you know, when Thai kids are trapped in a cave or miners are trapped deep down in a mine, we sure don't do cost-benefit analysis. And the extreme version of this, I think, is actually the rescues that the military will undertake in war. Will go after corpses. And they actually follow, I think, a feasibility norm, because feasibility is really possibility. If it's possible to reduce the risk, you should. It's not possible because you destroy the activity, you don't. Well, it's still a feasibility possibility norm. It becomes ultimately foolish to attempt to rescue even a corpse if there's no chance of doing it. So it's the chance of doing it that is the success. So it can govern what we would call in tort law, correctly, we call it morality, I think we call it everywhere, an affirmative duty. Okay, you can have an affirmative duty that's governed by the feasibility standard. And the reasons for that have to go, and here's where the example I think is pulls me away from certain central themes in tort law. There are very particular values when you think of the military. You start thinking of Durkheim and the value of solidarity and how it is the affirmation that everything the military is about would be destroyed if everybody in the military acted on cost benefit understandings. That's not a place where the morality of the marketplace could enable the institution to flourish. And it's very specialized. We don't think of the workplace as, notwithstanding Marx didn't take in this respect, we don't think of the workplace as a natural habitat of solidarity. So justification here has to be more about the value of life. Irreparability, it doesn't have that particular value component. But a norm like feasibility can apply to negative duty. It can apply to affirmative duty. It could apply to reducing natural risks. Okay. Now, on the second one, what I think of as the third part of your question, or part of your second question that I answered here didn't answer. I'm not sure between two different things. I think we're thinking about what the domain of morality is differently. For example, some things we should protect ourselves against, but they don't trigger resentment, right? So think of, you know, Rousseau. Men resent injustice, but they don't resent misfortune. They regret misfortune. So earthquakes are misfortune, natural forces are misfortune. Somebody else imposing risk on you that they could have avoided had they taken more precaution, and they should have, that's an injustice. Okay. So I think that we're talking about a certain domain, and we would care behind the veil of ignorance about institutions that goes beyond Rawls, because Rawls is concerned with justice, but you can certainly do a veil of ignorance where you start asking, how should we approach natural disasters as something that we need to address? But they would be different from a question of justice, because the question of justice would just arise in, so if we're mitigating natural disasters, who should be responsible for mitigating them, and how should we share responsibility for doing so? It wouldn't be what do we owe to each other in the core way it is with justice. So that's how I tend to think about the domain. But the other thing that I think that goes on is, I think you and I have very different views of how much affirmative duty there is in the law of torts. I think, for example, that terror stop is just straight affirmative duty. It isn't a borderline case of negative duty. I don't know if terror stop is known on North American world, but terror stop is a famous California case where a student at the University of California at Berkeley went to see a therapist, told the therapist that he was going to kill his ex-girlfriend who'd gone away for a semester in South America, and that he was going to kill her when she came back. Therapist believed boyfriend. Therapist told, I think, actually, the security at Berkeley, they didn't do anything. Girlfriend gets back, gets killed by boyfriend. And the California Supreme Court says the therapist had an affirmative duty to warn. I don't think you can make that at all into negative duty. I think it's pure affirmative duty. And I think the law just is willing and should be willing. This is, I think, where we have our disagreement. The other one about constructing the domain of morality is not so clear to me how we disagree. But I think the law should be willing to impose easy duties to rescue, and I don't find that troubling. And I think that may go to the difference between an interest view of rights and a view that negligence is grounded on our interest in physical integrity as opposed to grounded on powers of choice over other people and so on. So that's why I think your second question splits into multiple questions.
Thank you. Thank you, Greg, for your presentation. I have two questions. Initially, I had one, but something that you mentioned at the very beginning made me think of another. So I have to start with the second. And I wonder, because we have enough evidence and I think enough agreement that tort law is very bad at the system of reparation. And so what I tend to think is, well, they must be doing something else, right? It's so bad at doing that. And so why we are still assuming that starting point again and again and again in tort theory in general. And so I'm trying to question that. And you mentioned, yes, there is something about expert theories or something about damages that could bring some partial answers to this problem. But what I don't see is, or I see that this is an underdeveloped thinking. And I want to hear your thoughts on that, because I don't see that, I see a lot of, but expressive theories, we can just build and continue. And I'm interested in exploring more about that. And I'm interested in exploring more about what is really the meaning of money, whether there is something that also guilty damages depends whether you have a defendant-oriented perspective or other perspectives on that. We can talk about that later. But this is one aspect I want to push. I will not assume that speaking so much with the assumption of reparation and whether there is much more to explore there. And then the second question is about the limitation to take the relationship towards regulation. I think it's very interesting and also challenging, especially if you consider the American landscape, right? Because you have a regulator that is dominated by the cost-justified precaution idea, and C itself, the role of the regulator is dominantly that one. And so what I was wondering is whether it would be helpful to get in that conversation, which is the regulator you are advocating for. It's a regulator that is much more sophisticated, that has to get into a nuanced judgment of risk assessment. It's a different kind of regulator than the one you actually have in that context. I'm trying to push the thinking of autonomous vehicles that you are trying to connect. I was wondering whether it won't be useful to look at the AI Liability Act at the European regulator. Because what they are trying to do, I think, fits a little bit with the distinction and saying, well, when we prohibit certain activities, we are following a safety standard in this risk-based approach. There are other activities that we are not that sure, and maybe it's a little different standard. And at the same time, this is dynamic because it changes. Because of course, in the context of new technologies, we don't know there are activities that so far they are not high risk, but they could become high risk. And so there is a role of the regulator that is, I think, much more in line, if I understand correctly, for what you are thinking. It should be the role of this direct regulation that is rescuing folks in this idea of preventive harm. So I want to hear a little more about that and whether these ideas are getting or not. Thank you.
I think that second question, which I'm starting to puzzle about, because I think I probably should start thinking about both AI and autonomous vehicles. One of the things you're pointing to is uncertainty, right? And in the feasibility standards and safety standards in environmental and health and safety regulation, the problem isn't uncertainty in the sense that we don't even know objective probabilities. They go to lots of trouble and it's very time consuming, and perhaps that's one of the problems because administrative processes can grind very slowly to assess the risks in pretty refined ways and to gather lots and lots of data. But one of the things that we are facing with artificial intelligence and autonomous vehicles is not being sure from one moment to the next what set of risks we're assessing, okay? And then we're also facing this somewhat, this may be the wrong way to frame it, but it tends to get framed as much for rhetorical reasons because there are very powerful interests that are pushing things like autonomous vehicles as, but just a question of substituting a safer technology for a less safe technology. And when you frame it that way, you're framing a classic sort of razor's edge efficiency standard. If you've got one level of safety and you can improve it by any amount by changing a technology, well, of course you would, right? And that isn't our view. The lay view, I think, and all of our views actually of autonomous vehicles is that's spooky at a certain level because that's a machine, it's not a moral agent. Does it recognize me as a cyclist, or does it think I'm a tumbleweed and no problem running me over because tumbleweeds aren't important things in its programming? And so we want a much higher level of safety. And I don't know if it's because, is it because of uncertainty? I have the feeling it's because we can't count artificial technologies, artificial intelligence or AV as moral agents, and therefore the responsibility has to pass through to somebody else. But in practice, in the legal system, we're trying to wedge them into categories where the only things in those categories before were actual persons who are moral agents. Like whether, while we think about it in academia, autonomous vehicles are showing up on the streets of Los Angeles, and they're going to be treated in terms of a traffic code that's designed for human drivers, even though nobody's going to think that when either a Tesla or a Waymo AV violates a traffic regulation, it's accountable in the sense that a person is, and we're going to ask if it's drunk and whether it went to, we're going to think driver's ed school, and we're going to think, you know, lapse of responsibility and so on. It's nonetheless going to be wedged in there, and it's very puzzling to know how we should model that. Coming back to the first one on expressive damages, I think why do I come across as a bit ambivalent about them? It's because you can develop expressive damages with great subtlety, but the problem that people are facing is they're not getting adequate protection against getting killed. And after the fact, articulating the expressive significance of damages with great subtlety, it has its appeal because it's very interesting and because you can say very refined things about value, but it can seem a little bit like in the cases that most bother me, which is only one kind of case, it feels a little bit like missing the point, okay? But that's a particular kind of case. For example, in thinking about your paper, I started thinking about Scott Dershowitz's favorite case, whose name I always forget, but it's the case where somebody who's rich, powerful, arrogant, at best arrogant, probably much worse than arrogant, spits in the face of somebody else when the other person like wins a lawsuit against him or something, and doesn't just spit in his face. It's like, you know, cultivates the spit before he spits it in the most offensive way possible. And that's a case that Scott thinks of as, maybe he thinks of it as expressive damages, maybe he thinks of it as the expressive role of process or something like that. Maybe you could think of it as the exercise of power. That is, this guy exerted raw power over me, and my calling the court for their assistance and making him pay a lot is exerting raw power over him. I think that's a very, very interesting thing, and it doesn't, what I'm thinking about doesn't respond to that. And I also think there are clearly things going on in ordinary tort law that are not about reparation. They're about just that the process element is calling somebody to account So the process of bringing someone to court and offering your account of what happened and holding them to account for having wrongly harmed you, that itself has got to be part of the value of tort law. And it has to be the case that damages in some circumstances not only contain an element to respond to that, but are the best we can do with it, because what we're responding to isn't the irreparability of the injury, it's the kind of disregard that the defendant showed for the plaintiff, or it's the kind of harm that the plaintiff suffered that somebody shouldn't have to suffer, and we've got to make a kind of eye for an eye, tooth for a tooth suffering on the part of the defendant. So in all those places, my kind of uncharitableness only applies to, it's not really the point when people get killed. And man, of course, I'm inadvertently killed. I hope my children get wrongful death damages and build a monument to me and everything, but I prefer it that it not happen.
Thank you, Greg. I'm just trying to find my old notes from our last meeting that in those days, I have a comment that I didn't use in our last discussion about the city.
I have that problem too. I lose my own comments.
But
I'm still
trying to reconstruct the idea. I don't fully understand how you analyze the asymmetry between costs and benefits when you criticize the way of analyzing negligence and liability in general, because as I see it, on one side of the equation, for the equation, you have costs. Costs sometimes have monetary value, sometimes do not. Paying more attention or not doing something that has non-economic value. So it's measured in terms of liberty. You lose in order to what? To protect what is in the other side of the equation, which is a reduced risk of physical harm. Right? So the benefit in the cost benefit analysis is protecting your physical integrity. Right? And the cost is sometimes losing some freedom.
Yeah.
And I don't see now how this is problematic for one economics. It seems quite sensible to think, okay, at what cost can I reduce 1% of the probability of you suffering some physical harm, which is the cost to me. It doesn't sound like an absurd question. It's quite.
Yeah, no, I think.
This is the first, then I have.
Okay, do you want me to go with this one or not? Maybe let me make sure I'm tracking it. It turns out every now and then I get some economists who are sympathetic to me, and we're saying driven much more crazy by Arthur or Ernie than they are by me. And I think it's because you can count that as a point of progress. You can regard that as vindication. I regard that as some alarm. You'd always like to convince people, but you're not sure you've convinced people, as opposed to as this was thinking, oh, I'm not quite saying that. But the so what the economists can think is it's just a matter of valuing the interests, right? I think, and that whether you call it liberty interests and security interests, or you call it costs and benefits, it's just a matter of how you value it. Okay, but I think there's something more going on in cost benefit analysis, and it is that it's the idea of universal fungibility, right? And I think I have an interest theory of rights, but I have a theory that some interests are more important than other interests. And the problem is how to find terms of trade-off that respect the superior importance of some interests relative to others, and that is what the safety and feasibility norms are doing. So they're articulating different terms of trade-offs. You're not just deciding how valuable the two interests at stake are in terms of just put more of a thumb on the scale on the side of security and add more dollars to it, which is why I think the economists think I'm making a kind of sense that say Arthur and Ernie aren't, and that I'm not as far from them as I think I am. And I think the answer is you could get something that would look like what I like by jiggering cost benefit analysis. But I think what you'd be doing is trying to track what you get if you think about it the way that I think the law thinks about it. And the law isn't really thinking about it in the way that cost benefit analysis is thinking about it. So you would generate a cost benefit analysis that can track it. But it isn't the, it would be sort of like a sociopath. Well, that's too harsh.
I agree with the criticism if you take money as an end. But I don't think any scholar now thinks of money as an end. When you are investing a lot of money to save one life, this is money that you cannot use to save many other people. There is a case in Brazil which was famous because the Supreme Court allowed for the experimental treatment to cover the sight one person who was the claimant. But the treatment was so expensive that according to the laws, it was just one town had to pay for the treatment. That town didn't have now enough money to give some medicines or regular meals to treatment for treatment or in public hospitals. So money is important because of what we do. It's not money, it's what is behind money, what we can do with that money, and it doesn't make sense.
Right. So no, I do have a couple of comments on that. One is, I think in thinking about the difference there, we have to start sorting things out in a somewhat different way. The standard economic way of thinking about something like a railroad accident. A railroad accident happens because somebody doesn't throw a switch, okay? And an economist gets in there with cost-benefit analysis and starts asking, kind of from the point of view of God, so how much should we be valuing all of the relevant interests here? And does it make sense to spend more preventing this one railroad accident when we could be preventing, malaria among children in the third world or whatever? And it's just entirely not the question of responsibility that's framed by the issue at hand, all right? And there's a characteristic of economics to move. I mean, one of the things that you think in the statistical logic literature is to move to the idea that everything was being decided from the point of view of God. You got to figure out what is that underlying idea, what drives them to think that way, and then to articulate why it is that questions of interpersonal responsibility have a very different structure, okay? And there, I wouldn't be close enough to Arthur for Arthur's to make him happy, but I'd become closer to Arthur. And then the other thing going on is there are some things in economics that it's kind of hard to figure out what the real structure is, because a simple version of economics would be old-fashioned cardinal utility, okay? It would just say, what we want is to get at cardinal utility, and everything has a cardinal utility. And we would try to figure out some index for that. And if money's not perfect, we try to find some other index, okay? But modern economics rejects cardinal utility and goes for ordinal utility, so that it just focuses on everything as how one person would rank various goods. But then when it tries to get interpersonal, it turns around and says, well, what would people be willing to pay? And when you turn around and say, what would people be willing to pay? I think you're kind of bringing cardinal utility in through the back door. And if you've got cardinal utility, then what you really have is a theory of value that is homogeneous, in which there are not qualitative differences in value. And I really do have a different view of value, and everybody, not just Toronto Kantians, but everybody on the liberal side of the divide has a very different view of value, and so do Aristotelians. So, and I think economists really are sneaking a cardinal utility view of value into their cost-benefit analysis when they make willingness to pay the critical criterion. Is that on? Yeah.
I have a question. I got the second question. And the second is again about the peace and the peace.
Oh, yeah, we talked about that in a different country a couple months ago. That's not
These things.
David thinking
I
about
guess
this.
that one. Now, just one more question. For you, is this case of strict liability? or not?
Well, yeah, it is because, but I would also say eminent domain is because
No, but then you keep saying that it's a case of efficient precaution.
well, the correct level of,
This strict liability.
oh yes, the correct level of precaution to take against the harm. So Vincent, one probably has to, I think I'd have to write another paper on Vincent. I think I've regarded it rightly as, he is obsessed with Vincent, but I have to write another paper, but you can look at Vincent through several different lenses, right? So one lens to look at Vincent is, it's a mandated rescue piece, okay? Because the ship owner gets to use the dock owner's property for an easy rescue, okay? Another view of Vincent, it's a trespass case, okay? And my view says, well, I think it's a privileged case where I'm not really resisting the entry case, but I am resisting the trespass one because I think the right to exclude part of your property right has been extinguished. But I think Vincent also illustrates the fact that there's nothing to criticize in the conduct of the ship owner. It's one of the traditions on Vincent. Richard of Epstein is the principal proponent of this, says, well, think about this as a case of a single owner, which is an idea that has deep roots in American negligence law. Very early formulations of negligence law in the 19th century say, the way we should think about the level of care owed is in terms of if a single actor owned both the imposition of the risk and the harm from the risk, what would they do, okay? And Epstein says, well, in a single owner case, you take exactly the precaution that the ship owner took, which is damage the dock, don't try to save the dock, but you'd also have to bear the cost of it, okay? And that's Epstein's way of explaining why it should turn out the way it should turn out, okay? In my terms, it illustrates strict liability because I think the most common version of form of strict liability in American law is one where it is not wrong to inflict the injury, but it is wrong not to make reparation for the harm you've done because it's wrong to make the victim bear the loss. So the way you would put it in Vincent is it's wrong to transfer. This is actually Holmes's term, I think, when typical Holmes is 2 sentences on Vincent, but wrong to transfer the loss to the dock owner. Okay. Then back to our earlier conversation, there's no residual reasons because once you pay reparation, this isn't Sophie's choice. This isn't the stuff that was John Gardner about, tragically, you're drowning and I should be able to rescue you, but I can't rescue you. And so even though I couldn't possibly have done it, I've still got it.
But still is the case that the ship owner did not take any precautions. You claim that took deficient precautions that were zero.
Yeah, no precaution.
It's no precaution. So, and the single owner case also is very problematic. That the literature about.
Oh yeah, the single owner.
Another case is not the standard of here we say alterity, like being in a relationship, knowing that there are others, it's not only about you.
Well, no, I criticize all of the economics for collapsing. So I don't own Richard's analysis, but it is a metaphor. It gets one piece of negligence, I think, which is under negligence in a very basic way, it does require you to treat the victim interests equally with your own, right? You can't be a complete egoist under negligence law. You've got to be impartial between your interest and the interest of the other person. You also don't have to be an altruist. The single owner gets that, but it's not an adequate book. Chapter 4 of my book, attacking that, and because it's a dominant metaphor for the economic analysis, and it destroys the problem of interpersonal justice that's at the heart of it. So I don't generally favor it, but I think it makes it illustrates an aspect of Vincent. I mean, one of the things that makes Vincent, one of the articles of Vincent that approaches it from a rescue point of view has a little footnote saying, "Here's my RA, look it up." It's been tried 12 times in cases but 300 and something times the law review arguments, okay? And one reason is there's a lot of different prisms that you can look at Vincent through, and figuring out how do you put all the prisms together is pretty difficult.
Thank you, Sir Keating. I have some questions for you. The first one is about what we think of if we as citizens or persons, we have a legal entitlement to force the implementation of these standards that you talk about.
Say that again, if we have a
legal entitlement, an action, a
Okay.
legal action to force the implementation of these standards. I say this because we in Colombia, we have this insane case that asbestos only was banned until 2019.
wow.
While in Europe, you know, the consequences of asbestos, Europe was banned in the decade of the 70s. But we didn't have any legal action to force to the Congress to regulate these, to apply any of these standards. So do you think that we have this kind of legal actions? And if your answer is yes, and what kind of justice are we implementing in these cases?
So if we don't, so I think the question is if we don't have a statutory scheme, what kind of justice are we doing? So I guess in the American system, what you do is you default to tort law. It is the default. It isn't. There are problems with this as anything more than a metaphor for these purposes, but it's the default risk regulation system in the United States, and that means if it hasn't been displaced, you go to tort law. And I suppose the right thing to think in tort law is asbestos. I guess asbestos falls into a feasibility standard, although when we figured out how dangerous it was, we just banned it. Okay, the question is really whether, in the American history of asbestos, the disaster happens primarily as a result of World War II with massive shipbuilding for the war, and asbestos being an insulating material of unparalleled effectiveness, and shipyards being snowing asbestos in the course of constructing ships. And if you think that the construction of those ships in time of war was urgent in a way that is very pressing, and that there's really no substitute for asbestos, then I think the correct standard to control it is a common law feasibility standard. The history of asbestos as it unfolded in American courts was complex, partly because there was this huge time lag because of the latency period for the development first of asbestosis and then mesothelioma, but also because to the extent that courts were able to figure out what happened with asbestos, it appears that the companies that Johns Manville in particular did some research early in the development of asbestos. The research was turning up information they'd rather not know, and they stopped. And so that presented a very difficult negligence question, which was, were you negligent because you failed to undertake reasonable research, facing back now decades, and should we hold you liable for that as a matter of negligence? And courts cashed out solutions to asbestos in terms of failure to warn, and let's not worry about the fact that the risk is unknown. You didn't warn about it. That had the administrative virtue of getting around and ending these endless inquiries into what was known and what should have been known 40 years ago. I don't know if that responds to your question or not.
Okay, and the kind of justice that you see in claiming prevention of harms.
So I think it is an interpersonal justice, but I think the communities of risk involved vary in sort of concentric circles. You can think of some torts cases as involving only two parties. All right, I don't think that it helps to think of, say, even product accidents use. That is because it's everybody who's exposed to the risks of products is the community that has the risk imposed upon them. And I think that's a form of interpersonal justice. I would take interpersonal justice very far. I would take interpersonal justice all the way to the museum and access, say that regards the relevant community of risk as society at large. We're all in this together. It's an old fashioned, but in some ways very much in the spirit of walls are torn view of what we owe to each other, but very, very different from the particular community of risk that you might see in interpersonal bipolar negligence lawsuit. And if you think of the product liability in the intermediate zone between those, I think some of the questions of punitive damages is wrestling with have dimensions that are affected by the nature of the large scale risk imposed by even the sale of an ordinary product. And I would think of asbestos as involving that kind of large scale interpersonal risk imposition, not just a one-off idiosyncratic individual to person one.
Thank you, Professor.
Thank you.
Thank you.
Thank you, Professor Keating, for your conference, and thank you all for your questions. Now we will take a coffee break, and we will rejoin at 1 and at 11:20. After that, we will have our last conference, which is in charge of Professor Maria Guadalupe Martinez. And finally, the conferences will have lunch here at Casa Externalista, which is the restaurant of our university. Thank you. You can get your coffee outside. There's someone, and also there's cookies.
Yeah.
Yeah. It's like.
Express.
Yes.
Nobody will engage with I mean, everyone loves a parade.
You know, it's, but it's.
Yeah.
Sharing some ideas on the significance of the private actor. And first, I would like, before I get into the core of the paper or the main ideas I want to convey with the presentation, I would like to say make some preliminary remarks to put some framework into the ideas. First of all, the core ideas of this presentation belong to a larger project, which is a monograph on the relationship of between torts and retribution that is embedded in punitive damages. Hopefully out this year or beginning of the next. Let's see. Doesn't depend on me exactly, right? It depends on the timing of the press. But hopefully, we can have opportunities to discuss this further later. But so this is just to say that the bulk of my research agenda in the last year has been focused on devising a relational retributive reconstruction of punitive damages that is inclusive of the victim's perspective. And so this is what explains my focus on trying to elucidate the significance of the private actor torts, and also my reference to punitive awards as examples that I think can illuminate the importance of these aspects. And so basically what the project is trying to do is to advance a contextual and interdisciplinary approach to torts by integrating insights from cognitive science and social psychology to better understand that, the substance of the victim's perspective. And so the selection of this particular methodology comes from two dissatisfactions that one has to do with the polarizing trajectory of the tort theory debate, which originally presented a structure and function as opposing poles, as if they were incompatible. The second dissatisfaction is with thinking about tort law and victim as if they exist in a vacuum or in isolation from the substance of their responses to wrongdoing and from the broader context in which wrongdoing happened. And so what I try to do is to move away from the structure function dichotomy by showing instead a subtler interplay between structure and function, and also to show that integrating and striving to understand the victim perspective is worthwhile, in that victims are essential elements that complete the picture in the relationship between defendant and plaintiff. And so the idea is basically to offer a more holistic approach to what it means to be wrong and what holding others accountable entails. And so lastly, in these preliminary remarks, I would say that implicit in this line of argument that I'm interested in are three elements. First, the blurring of the private-public divide. I see more interactions, intersections, and overlaps than pure distinction. Second, an attempt to close the gap between law and emotions, or law and intuitive judgment. And there, what I would like to is to overcome the fear of giving room to intuitive motivations or to emotions without advocating that the law should blindly follow emotions or intuitions. And the third implicit element is a pluralistic account of tort law. So the fact that I am interested in looking at the substance of the victim's perspectives to wrongdoing open up a path for the identification and exploration of the plurality of competing values that surface in the articulation of tort law and its process. So let me get into the core of the ideas. So because my focus is on understanding the significance of the private actor in torts, what I do is I start by identifying the available dominant depictions of the private actor advanced by functionalist and structuralist accounts of tort. And so in a very simplified way, we can say that functionalist accounts of tort law depict the private actor as a contingent agent who instrumentally contributes to wealth maximization by assuming a kind of enforcement role. And so under this reconstruction, the victim advances a public interest which is external to her. And the wrongdoer-victim relationship is contingent in the sense that it is mediated by this ultimate goal of achieving efficiency. And so this contingent actor depiction correlates very well with a market-oriented idea of tort litigation. That means whomever is in the best position to litigate should do so. No? The idea of third-party litigation goes on that line. And so the private actor is basically understood as a rational agent what means that any other motivation, apart from efficiency or wealth maximization, the victim may have for pursuing damages awards through tort law is considered in principle misguided, irrational, or mistaken, and in need of some sort of correction. On the other hand, conversely, structuralist accounts of tort law understand the private actor as a necessary element of the bilateral structure that determines this normative structure of tort law as private law. And under this reconstruction, the victim advances a private interest, which is internal to her. And so the victim seeks private gratification or private redress for the wrong done to her by the wrongdoer. And so this depiction is well entrenched in right-based approaches to tort law, broadly understood, and civil recourse theory as well. And so rights-based approaches assume that what the victim ultimately wants is private rectification by arguing that tort law places the defendant under the obligation to restore the plaintiff as far as possible to the position the plaintiff would have been in had the wrong not been committed. And so this restoring of the normative equilibrium back is all tort law is about, no? The allocation back idea. So whatever lies beyond restoration to the victim's rightful position is external and thus foreign in principle, foreign to. Civil recourse theory offers, this in my reading, offers instead more sensitivity to the victim's perspective by approaching tort law not as a scheme for normatively restoring the equilibrium between defendant and plaintiff, but rather as a mechanism that empowers private individuals to seek private redress for relational wrongs done to them. And so, however, by focusing on the structure and logic of the empowerment, power allocation idea, they end up depicting the victim as detached from the substance of their responses to wrongdoing. So, to sum up on these ideas, however different, all these reconstructions of the private actor, which again I offer in a simplified way, in my understanding, they share a commonality. And this commonality is that they are formal and abstract depictions of the private actors in torts that are assumed in order to fit the structure of their own theoretical frameworks rather than empirically explore. And so what I try to do with this project is the latter, to empirically explore them by offering a substantive and contextual depiction of the private actor in torts. And so how this happens? The starting point first is the identification that the victim actually has a central role in the bilateral structure of tort litigation. Is the one who takes the initiative and actively decides to file a lawsuit against the wrongdoer. And so if the victim herself who has the power to subject the wrongdoer to the court's jurisdictional power to issue a reasonable judgment against the defendant. And so following this logic, the proposal is that to look at the correlative motivations of the plaintiff who ultimately decides to exercise her right to initiate a legal proceeding against the particular defendant. And so what are these correlative motivations? So the point is that looking at the victim's motivational compound is worthwhile. Why? Because it offers a different picture of the content of tort responses. And so it tells us that many times tort responses reflect a subtler interplay of private and public interests, whether rectificatory or not. And so these dominant public external or private internal depictions of the private actor are somehow ill-equipped to capture the richness of these much more textured responses that tort victims pursue by engaging tort law and the tort process. And so they cannot capture the moral significance and the situated meaning of the impact of torting wrongs to victims or the complex motivations for seeking redress through tort. The fact that the tort system offers a rationalistic approach that translates injury, pain, suffering, and other intangible harms into sums of money, or it would be like the commodification, in a way, critique of torts, does not necessarily mean that victims solely or even primarily seek monetary compensation in response to wrongdoing inflicted upon them. So without disregarding the need for compensation that many victims have after being wronged, such an assumption misapprehends the tort victim's motivational component. Tort victims often demand responses that go beyond private rectification. They demand responses that better match the moral wrong by conveying the significance and meaning of the wrongdoing. For instance, they want affirmation of the worth and dignity. They want communication of condemnation of reprehensible behavior. They want a public forum to voice the moral significance of the wrongdoing, to tell their stories, their own narratives, their experience of injury. They want affirmation that justice and equality matters in our society, and so on. So they seek responses that connect the wrongdoer to the victim by acknowledging the particular circumstances of the wrongdoing and their correlative motivations in a more holistic fashion. And so in this, when we think about tort responses, they will depend on the type of tort, whether it has affected property, bodily integrity, dignity, autonomy. Depends on the particular circumstances of wrongdoing, whether it was negligent, intentional, humiliating, outrageous, and depends on the significance of the wrongdoing that the wrongdoing has for the private parties involved. Where lies the moral wrong? How the manner of the defendant interference with the victim's protected interest is connected to the inherent value attributed to them in the particular circumstances of wrong. And so, for instance, if we look at insights from social psychology and cognitive sciences, they tell us that our responses to wrongdoing are different to carelessly inflicted harm than to intentionally inflicted harm. And so here the example of punitive damages might be apt. So when we are confronted with reprehensible behavior that affects incommensurable interests, such as our personal autonomy and individual dignity, we do not seek justification. Instead, what we seek is a response that helps us express our rejection at the gravity of the disregard with which those protected interests were invaded, along with reaffirming our own inherent value and the importance of other regarding interest in our society. And so when we think in that way, in this logic, exploring why victims want the imposition of a sanction, in this example, a punitive award, for the wrongdoing that they experience, direct our attention to the value attributed by the victims to the interests that were invaded by the defendant's wrongful conduct. And so perhaps a better understanding of punitive damages, for instance, arises from asking how we make sense of the circumstances of deliberate, humiliating, outrageous wrongdoing that threatens our personal autonomy, dignity, bodily integrity, or even life. And so other studies show that, for instance, in the medical malpractice context, the main motivation of victims is to get fuller information about their injury and determine accountability. Studies also show that in cases of defamation and invasion to privacy, the main motivations of victims is to be left alone to stop and correct the defamatory message, this idea of the right to be forgot. And so tort victims' responses, from this we can conclude, are complex and textured in that they reflect common sense understanding of other regarding values, which serve as the basic of collective understandings of collective standards of care and behavior. And so the bottom line I want to convey here is that accepting formal private verification or private redress as a satisfactory explanation of the content of tort responses means treating victims' responses as fungible or interchangeable, marginalizing the individual and social importance of articulating distinctive intrinsic motivations which are elicited according to these different intensities of the wrongdoing and the diverse nature of the interests that are affected. And so this would mean deflecting our attention from how we ought to behave to others to the fungible monetary award defendants must pay for misbehavior. So moving on this line of thinking, now that I have tried to construct a different, more substantive and contextual understanding of the private actor, this demands thinking about the tort process in a different way, re-signifying the understanding of the judicial tort process. And so a reading of the tort process as a mere instrument to achieve the goal of compensation is not only narrow and reductionist, but mostly misguided, because this has led scholars, for example, to question tort law based in our society, particularly its capacity and effectiveness to provide victims compensation in an all or nothing approach, arguing for moving away from tort law towards social compensation funds and alternative compensatory mechanisms. And so the problem I see with these all or nothing positions is not only that they are difficult to sustain because they are too much of a simplification of the practice in a way, but also that diverts the scholar's attention away from the substantive aspects of the operation of tort law that might actually recommend the institution. And so an alternative reading would be, that is what I'm trying to explore, is that of the tort process as a legitimate institutional avenue for addressing a variety of different responses to wrongdoing that in a way offers a unique approach to the problem of redressing private wrongs. And so, for instance, the tort process gives private parties the opportunity to question each other's behavior in a forum that reaffirms their value as moral equals. The victim has a unique chance to personally convey several distinct messages by filing the tort lawsuit, playing, as I see, a role that is both reactive and proactive. Reactive in that they seek an authoritative declaration of judgments of rights and responsibility in the judicial process, and proactive in that they take part in the public establishment of collective standards of interpersonal behavior. And so by doing that, I see victims infusing tort law with meaning. And so by denouncing the reprehensible wrongdoing, in the case, for example, of punitive damages, victims made clear that her experience of injury cannot be reduced to a mere statistic or an economic consequence living in a complex society. Instead, it depicts the wrongdoing as a personal affront to her value moral equal, infusing tortious events with social and cultural significance, and demanding recognition of the relevance of our interpersonal relationships and obligations of care to one another. And so in this way, the tort victims generate substantive meaning of other regarding human interaction, informing legal doctrine and standards with the insights provided by the victim's perspective. For instance, in the case of punitive damages, would be what amounts to reprehensible behavior in that context. And so under this reading, and starting to close the ideas, the tort process becomes what I think it is, an intermediate structure for participation that basically allows victims themselves to engage in the collective construction of the social and cultural significance of what it means to be wrong and what holding the wrongdoer accountable intends. And so this points out to the importance of appreciating the value of lay understandings of care and respect for others, and try to incorporate them in the decision-making process. And so the adversarial tort process provides an institutional framework for the production of relevant information and knowledge regarding the particularities of the wrongdoing and the underlying social and cultural conditions that only the tort victim who experiences can properly convey and activate. And so the victim is basically the one who is especially situated to expose the underlying institutional arrangements which facilitated the wrongful behavior. And so what she does is exposes them by requiring the defendant to explain, backed by the jurisdictional power of the court, how the wrong came to pass, and fundamentally, the tort process does this, questions the defendant's behavior. It forces the defendant to justify her behavior to the victim, to explain how and why the wrongdoing took place, and what reasons she may have for believing it. So in these clarifications lies the potential of the tort process to uncover information, for example, of public interest, of structural schemes of wrongdoing or other pervasive power dynamics in our society that would otherwise sometimes go unknown or neglected. And so the cases of fraud liability, environmental litigation, asbestos litigation, food litigation, tobacco litigation are good examples of this. Of course, this does not mean to say that the adversarial tort process is perfect or ideal. It indeed has a lot of documented disadvantages. It's costly, time-consuming, affect victims, it's limited in the measures that can be offered, among many others that we can think about. But my point is distinct, is that there is something unique about the articulation of tort law that other available mechanisms cannot provide, and that it makes tort law a valuable complement to regulation and legislation. And so the fact that any victim can activate it, and once the victim files a lawsuit, the judge is duty-bound to provide an answer, is a powerful aspect of tort law that recommend. We can discuss, if you want, in the exchange, the problems I see with the alternative mechanisms, which are basically the depersonalization of the private actor and the privatization of the company. The fact that the less tort law we have, the more our rights and remedies are being redefined and controlled by entirely private actors. In any case, I'm closing. The ultimate point is that as a community, we should devote more efforts in thinking how to improve the operation of tort law and its process, rather than simply replacing it or moving away from it, because it offers an important complement in the functioning of our democratic society. And I think, thanks for your attention. I stop there. Thank you. Thank you.
I'm gonna change your microphone.
There were some couple of developments in the United States that have really put the sort of public-private interface of tort law and other private law in the spotlight. One of them was a really rather central aspect of the Me Too phenomenon, and it was that this was epitomized by Harvey Weinstein. He brought it to a level of perfection never seen before, but it was generic. It was that the power to settle private lawsuits privately was a way of keeping them hidden from public view. It was, he practically had his entire firm working in a coordinated way to make sure that he would settle cases with his victims the story would never get out. And there's a kind of absolutely pervasive feature of American tort law there, which is defendants will settle, and it's not just in highly charged context. It's every bit as much the case with respect to toxic substances or autonomous vehicles or almost anything you can find. They will settle cases when they conclude that the public significance of the case is clearly bad for them. They'll pay a premium to settle, and they will completely defeat the sort of public-facing side of tort law, and they'll defeat it by using the mechanism that's ultimately up to the plaintiff to settle the case. And I kind of wonder if your view doesn't, so my first question is, I kind of wonder if your view doesn't require that to go. Maybe that's my only question, but my second example is, there have also been prominent cases that are the interface of private law rights and social justice. There's a major one in Los Angeles involving actual reparations for racial injustice involving a beach called Bruce's Beach that the city of Los Angeles simply took from a Black family by eminent domain probably about 100 years ago. And they took it, and the family lost title to it, but you can figure out who the family and the heirs were. And there was a long negotiation recently over it. And when the heirs got it, there was a moment when, I forget exactly how this got resolved. There was a moment when they turned around and they said, wait, we're not going to sell it for 20 million. And they were backed by a whole bunch of progressive activists who wanted the beach to be a public monument of sorts. And it was a classic contrast between, well, it's yours, it's property, it's your private property. If you're going to do anything with private property, it's dispose of it as you see fit. But if you want to realize the public message for it, you don't want it disposed of, just sent to the highest bidder. You want it to be turned into a kind of public beach that's also a monument to, or a counter monument to something, a bad moment in American history, local history, and so on. And so the private power to settle is again sort of central there. It's another one involving Harvard University with a descendant of a slave who was photographed very humiliating, naked and without their consent, to say the least, by Louis Agassiz, who was the second most famous biologist of the 19th century. Darwin was the first, but Agassiz was a really famous defender of racial inferiority in blacks, and he had a very early collection of daguerreotypes of slaves, and they were using them as specimens. Someone recognized that as their ancestor and brought suit against Harvard, and went all the way to Massachusetts Supreme Judicial Court, which decided it was going to be a negligent infliction of emotional distress claim, which I think was mostly designed to bring Harvard back to the bargaining table. But that too presents this conflict between the private mechanism and the public meaning, because there's a way in which you get a hold of those pictures. You can sell them for a lot these days. There are people who want to collect, but somehow what we want with respect to those photographs is a different form of public memorialization of what they signify. Anyway, two long examples for maybe a simple question, which is, what do you think about a private power of settlement? Is it an impediment to your view?
Thank you. Well, first, I would say I have nothing against settlement, and but I think we have to get into what settlement means, and then we so you have completely entirely private settlements that are completely privatized in the sense that I was mentioning at the very end, where you can see that rights are being defined completely by private corporations. So this happens a lot in consumer conflict. And so these kind of settlements would be problematic because they are not only depersonalizing, that they are actually doing away with the idea of meaning that I think the thought process brings, and the idea of the public discourse, the public meaning of this other regarding values or understandings. But also this privatization, I think it is worrisome in a way. So these kind of settlements, completely private settlements, wouldn't fit. Then you have the kind of settlements that I think go more in line of your question, that had to do with the powers that private actors have in the tort process. And so, because the victim is the one that is initiating the tort process, but also is the one who has to continue it and see it to the end or settle if it sees fit. And so I think I don't have so much problem with that power of private settlement in the sense that there is some judicial overview of this kind of settlement, there is some counterbalance of the power dynamic. It could be that there is in the context of a litigation where there is a power imbalance or a power asymmetry, but the fact that it has some public dimension because it is in happening in the tort process, it has some judicial overview, then I don't think this would be problematic. So I would to your question, the answer would be it depends in which context this power is being used, and when privatization or depersonalization is completely undertaken, then it would be problematic. If not, it wouldn't, and maybe there is some refinement there to be done in the understanding of what losing completely the depersonalization or what privatization actually means. So I think it's a great point to explore more and refine. But this would be, I don't know if it is the status
So I actually want to thank you for your paper. I want to follow up on your response to Greg's question. I was going to ask a less informed version of Greg's question, but I'm now better informed. So I want to hear more about the way in which you're conceptualizing personalization here. And one way of bringing that out is to think about the beach in Los Angeles example, because there, on the one hand, is something deeply personal and humiliating about what happened. And so you might say, oh, well, so that should really be the content of the appropriate remedy. But there's another way of thinking about it that says that what's depersonalizing about it is that the ancestors who owned this beach were treated not as ordinary people with ordinary rights of property owners, because eminent domain was exercised and then it was, I take it, just sold to somebody else because that's what they wanted to be. And so the depersonalization doesn't seem to be understandable, or it can be understood in two different ways. On the one hand, there's a kind of element of insult to it. And on the other hand, there is an element of not having standing as fully fledged right holder. And those seem to lead to quite different views of what the appropriate remedy would be. And so that's one version of it. But I also have a further question about settlements, which connects up with the way in which you're drawing on social psychology, because you say that social psychologists and studies show that most people sue because, and then you say because they're outraged and so on. And certainly when I teach courts, I always kind of represent the plaintiff as outraged. But of course, I never teach cases that have settled. Settled. I only, HLA Hart observes that when you go to law school, you study appellate cases. All appellate cases are pathological because they're the ones that couldn't simply be resolved clearly with doctrine. The least pathological cases are the ones that settle, where both sides can see kind of where the doctrine is pointing. But the question is, in what sense is outrage central to the operation, as opposed to something that only manifests itself in these pathological cases? There are, in Toronto, there are lawyers who are known as the lawyer you go to if you're not willing to settle, no matter how good a deal you get. It's for people who are just angry at each other. A friend of mine was a lawyer in Greece briefly, and he acted in an unjust enrichment case for a shipping magnate who had given $100 million to his son-in-law, and then the marriage dissolved. And so he demanded repayment, whether it was gift or whether it was a loan. And so And here you have it, it's really about outrage. It's just not clear they're victims here. Because each of them were billionaires, and it was just, and that seems like a really pathological case. And the question is whether, to understand our law as we have it, we should be focusing on those. Because of course there's some things that really outrage us. But again, I'm just kind of interested in the analytical question.
Thank you. Well, regarding the thank you for the question. I don't think I have answers to all, but I will try. Regarding the first point about depersonalization, I would say that is a good example because I mean what I was thinking originally depersonalization is the fact that if victims don't have this avenue, this emotional avenue for expression, what we are losing as a society is the rich moral insight that the victim's perspective brings into the discussion. And so I was more thinking in your comment on the insult part of the ideas, I want words, but now I can see that in the standing element, you could perhaps also construct this idea because there is an insight there to be drawn from the idea that well, I don't have a standing to protect the property and so on. And so I'm not that sure that these are such different understandings of depersonalization that maybe think further about it. But in a more umbrella, broader understanding that I had in mind, I think I could probably explain these two facets. I don't know if it is satisfactory or not, but I think it could be something there. But basically, I am worried about losing the meaning of this kind of that happens in the thought process. This idea of the meaningless role of the victim is what I am talking. And this is what worries me about having such a few thought actions. You're totally right, and especially in the American context, most of the cases are settled, right? And so that's why you cannot find a lot of examples when the outrage things come in a different way. So they go all the way because it is something else in this kind of case, right? And so I'm not so much thinking of this particular kind of cases that is more, it sounds more like a personal just outrage focused litigation with just the goal to defeat the other party just because I'm rich and I can. I am thinking more of genuine reactions to reprehensible wrongdoing. And while I go to social psychology, and this is of course a question that I get very often, it's not of course it's not that idiosyncratic in a way. It's because I am interested in looking at what are the correlative motivations. Because when you as a victim decide to file a lawsuit, you are getting into something that is costly, time consuming, and so on. And it could even harm you at the end, no? It could be like draining and emotionally affecting you and so on. So there has to be something else to be able to want to do that. And that's why I wanted to explore the idea of basically there are two retributive motivations I'm interested in. One is moral outrage and the other is trial aversion. But basically trying to understand whether there is a relation there to be looked at when a victim activates a total lawsuit motivated that towards the defense. So this is what I mentioned at the beginning, the relational idea. And so I'm trying to connect why would you want to sanction reprehensible behavior. And these are motivations that are very powerful in that regard. But again, I'm not thinking of emotions in that way. No, I don't think this insight provides that. They provide a much more thicker understanding of these retributive motivations that actually points to the value. I am outraged because I value my autonomy, my physical integrity, and you are not allowed to diminish me or to humiliate me or to put your interest ahead of mine. And there has to be an answer for that. This is what I'm having in mind. But Because for many, going to social psychology is not convincing. We could also think of moral philosophy, no? Like the reactive attitudes are one explanation of that, the attitude of resentment, for example. And so I think there are other explanations that point in the same direction, that they are not only focused on the psychology or psychology. I don't know if I answer. Yeah, more or less. I feel I missed something. Thank you.
Well, thank you so much for these very interesting ideas. Like Greg and Arthur, I'm very sympathetic to your thesis and do not mean that this reaction as critical or hostile. There are two countervailing considerations that might interest you, maybe not. And I think they derive from your interest in punitive damages or the punitive increment of damage, where you take for granted the rightness of the claim at some preliminary level. Is it possible, or there's back up? Do you think that the reform or the shift that you have in mind needs to worry about claims that are bad in some way, dishonestly pled, or unsound or misplaced? I'm not very interested in that. I think forensics take care of dealing with bad claims, but I did wonder what you think about the idea of treating like cases alike, whether you value that as a goal, because it seems to me that the more we listen to and defer to the victim's perspective of an injury, the more likely it becomes that awards or judgments will be inconsistent with one another at some level.
Yeah, thank you. Thank you very much. Yes. Yeah, I would say, of course, I mean, arguing for more personalization and for a more individual basis attention or perspective could lead to what you're mentioning. But I wonder whether this is so worrisome or not, because at the end of the day, thought is case by case, right? I mean, what we do with that, we look at the impact when we think about damages, when we look and we have to quantify damages, we look at the impact of the victim. And of course, victims are different, impact will be different. Maybe, I mean, I would think about that, but I'm not sure it's that worrisome, that distinction. But I want to clarify something about the victim's perspective, because not to say like, well, whatever the victim wants has to be granted, right? Of course not. It's just that I think that getting into the substance of the victim perspective, let us think in a better way, or what I think in a better way, or let us to a better understanding of thought. This is what I was saying in the beginning when I reacted to Greg's comment, in the sense that I'm actually interested in pushing this assumption of rectification. And so I want to understand why we keep having tools rather rectifying, but we keep having it, we see value of this, and I want to know what is that value. And for that, I think victims provide something that has been underexplored in scholarship and in theory in general, that it points to substance, it points to values, and it points, I think, to a better understanding of why we have thought about all. And maybe the importance of thought is on these more marginal exceptional cases, and not on the vast majority of cases. And I want to be open to that possibility as well. But thanks for your point. I will think further. Diego.
Thank you, Juana, for the presentation. Really a lot. Just two questions, maybe, and one mark. The first is the methodological question. I don't see exactly how you overcome or you just break this dichotomy between internal, external. As I read your project, sounds like a constructive interpretation. You are trying to see which values make sense of the total we have. We try to see how these values fit the practice. This is constructive interpretation, and I will place constructive interpretations on the side of internal theories. they're concerned with the values, how we understand things, all the conceptual apparatus has to be respected. If it's distorted, then we cannot see the value in it. So I would say that your project is more aligned, even though you place some weight on some other functions, public functions of the law. The main lines of the project, I understand it as internal. The second, now, second is a comment, is why it's important to pay a daily account to what victims want? Why victims could be completely misleading? They could be expressing kind of sentiments or emotions that in a civilized society we should leave aside. So, outrage. I feel that. Like something in Spain, I was one of the victims of an electricity company that overcharged the consumers. So I get a bill of 1,000 euros for 1 month. Too much. They threatened me to go to court. I talked to other people. Most people didn't get a bill that big, but maybe they got 300 euros, 400 euros, and they pay immediately. I go to court. I'm still waiting for the judge to decide. And I'm really outraged. But at the end, they don't want punitive damages. I just want them to be sanctioned. It doesn't matter. No, yes, but it is just for current deterrence purposes. I don't mind about this is outrageous. This is it's not my main motivation. But if I have this motivation, maybe it's not the loss function to satisfy. Maybe it's not. Maybe the loss function is leave aside those motivations and just observe the fact that they are taking advantage of consumers writ large and implement some administrative procedures to control and to impose sanctions. I would be happy with that. So why is it so relevant to see what the victims want? Victims want unjustified things. And the last question is, don't you think that this is too broad? Because maybe even if you have plausible answers, that I know that you have, I've read some of your papers, and I think that the argument for punitive damages is compelling. Not completely convinced yet, as you know, I'm struggling to be. I'm not completely, but I'm more convinced than before reading the paper. So I'm more close to your view about how can we integrate the part of punitive damages in interpersonal justice, my interpersonal justice. Not completely convinced, but I see the point. See what the argument is. But this is not maybe the general justification for tort law, because in most tort law cases there is not something. There is no reason to be for outrage. And I have a car accident. You break my left leg. Okay, the insurance will take care of it. Even if it's a private matter and if the insurance pays, then you will have to pay to me. We still connected, and it's not to be outraged of that, right? So maybe the thesis, even if you have plausible answers for the previous remark, only is confined to understanding punitive damages, but not the general idea of tort law, the bilateral structure of law, why it's important to keep tort law and not replace it with compensation funds. For that, you need a different account, more like grave science, fine grave, or civil recourse. I think that.
Okay.
That's it. Thank you.
Thanks. I'm thinking while you're talking. First, I want to, if I get one of the answers, I want to say, I think I mentioned one of the ideas that is in the line of argument is this attempting to close it up between law and emotions and law and intuitive judgment. And yeah, I mean, very often I get this kind of reaction from that why emotions, now we put the name outrage, no? But emotions are broader than that, right? but so why emotions are important, why we should be looking at what the victims want, because in the very end, they want a lot of things, they could want many things at the same time, and they didn't change the amount of what they wanted and so on. And so, but my problem with that is, fair enough, but I think that the law is missing a lot with treating law and emotions as opposing poles. And I think there is some value into looking at emotions and to see when there is a mismatch between law and emotions, which mismatches matter and which does not. And we have to make that decision. And so when we think about the punitive litigation, I mean, most of the cases, I mean, I don't know of any punitive litigation that you can say, no, this is not, there is nothing here. I mean, I don't know if you know of a previous one, even the mad coffee, that is the paradigmatic coffee, that is the paradigmatic representation of the previous punitive lawsuits, it turned out that it has some. And so, this on one hand, this means that the third process has mechanisms to control emotions or intuitions, outrage, or whatever you want to call it. And so I'm not worried at that. To me, that is an explanation of why victims decide at all to activate the thought process in these kind of cases. But this doesn't mean that, yeah, whenever it's outrage, we should just go to talk and well, this is not what I am advocating. And so I see a value on that for what I just said. I think we are missing a lot if we are just disregarding emotions just because we think they could be dangerous or they could lead us to problematic answers to this kind of case. Then, when you explain your case, when you said you want to sanction, what you want is beauty damages. This is what beauty damages are all about. You want to communicate a message of condemnation to the corporation that is abusing consumers and charging over that. If this, that's the thing, for example, of the Johnson & Johnson litigation in the US, these are still filing lawsuits when they know they're not going to get a penny. They're not going to get $1 out of it because Johnson & Johnson tricked it through the bankruptcy. And so why they keep suing it? Because they want accountability, because they want some sort of sanction / deterrence, whatever you want to call it. And so when you say, yeah, I want sanction, but actually I want to deter them, well, of course, this is the whole point of beauty damages, no? Where we draw the line between sanction and deterrence in a way that what I'm interested in actually is exactly in that, in looking at the interaction between sanction and deterrence. I don't think we can think in only sanction terms or only in deterrence terms in this kind of case, but how these two interact. And so to see whether I can go a step further and see if I can convince you a little more, I see in the victims two elements. It's not only a retributive element, but a recognition element. And this recognition element is your idea of, I want to affirm my value as a consumer, right? You can just come and send me a bill of $1,000 for nothing. And I want to stand by it. And I want to recognize my inherent value as such. And so there is a recognition element that comes together, as I see it, with the retributive element. And this recognitive element, I don't know if makes easier the retributive one, but hopefully it does. Because it tells you, well, I want the position of assumption because I want to affirm my value as a moral equal towards the other party. And for that, the thing that I can do is ask the position of assumption. And then I have a whole process that has mechanisms to control that my outrage is not out of place. And that it has been reprehensible behavior in the trial and so on. Punitive lawsuits are not different. That's why there are few of them in a way. I mean, it's not that you don't have mechanisms to control that. And even in the US, in terms of quantification, this is the clear case from the 5 billion jury awards, they never stand, right? And so at very end, also the problem of quantification. The private public. Huh? Public-private. The methodology, right? Yes, because I think, I mean, I am advocating for a mixed understanding, private, public in a way, and I don't think I need to fit in civil courts or in corrective justice or in any other theory of tort law. Of course, theory of peace damage, but I disagree that this doesn't allow me to push the understanding of tort litigation and or compensation funds and settlements and all that. I don't see what you mean by that at that point. Because I mean, actually what I'm trying to do is to show that these theories cannot justify actually. In fact, this is what they do. I mean, civil recourse in the last version, they just don't say nothing about this damage. There are many reasons, I think, for that, but basically they don't want to get into the legitimate mess, basically, right? And
One thing for clarification.
yeah,
You think that the distinction internal external is not useful, or that are both useful? You need
I think they're
to
both-
understand, fully understand.
I think they're both useful.
Okay.
Actually,
I took it as
Ah.
you meant.
that's why I mentioned private, public, and mean internal, external. I mean, I think they're both useful, and I actually resort to both in order to come up with a mixture of both, in a way. But I would say private, public is more than internal, external. But yeah, this is what I use in this paper, but it's not what I do.
Well, okay, thanks for your presentation. I was wondering some more or less the same, Diego. I don't know if as internalist is your real enemy here, because I think in things like it's called Hercules one, and I think that is an internalist theory, at least the way I see it. So maybe the problem of your real enemy here is the concept of remedy. Maybe you're assuming that remedy is to go back to the state of affairs that was before the damage. But we can widen the concept of remedy and to include these kind of responses, meaning responses that we're talking about. So that's one question. The second one is about the recognition power of mind. Because I think that you're assuming that when we implement this kind of remedies, punitive damages, these punitive damages may this recognition power in favor to the victim. But I think that money doesn't have this power of this, or doesn't send this message clearly. Because in a very rich tortfeasor case, the very rich tortfeasor may anticipate the payment of punitive damages. And the respect to the victim is not clear in that case, even if he paid punitive damages. So in that kind of cases, it could be better to go with an apology or with some kind of remedies different only month. So that's it.
Well, I didn't know I had an enemy, but I mean, I don't see. I mean, I never thought in terms of having an enemy or a target at all. No, it's funny how you, because I never thought of that yet. And you're right, internal understanding a friend. I don't have, yeah, that's not, there is an enemy, this is clearly not. And exactly this point, I mean, I try not to, what I try to see is to articulate what it is out there. And so I'm trying to provide a reconstruction that identify the value of internalis and externalis there, and try to show what is the problem where we go, we understand from a purely externalist understanding or purely internalist. And this is something that, of course, I am opposing. I am clearly trying to see the middle grounds. And so I'm trying to close gaps between poles, one, the same structural function, and external law and emotions. And of course, it's a difficult task because when I'm trying to get into the complex areas of how these visions interact, I'm trying to come up with a new understanding of how I see retribution, punishment, and sanction in thoughts. So this for the first comment. For the second, yeah, you have a point. Of course, we're talking about remedies. And so, yes, I have an understanding of remedies that is broader than the verificatory remedies. Yes, I think that not, if we think only of remedies in terms of rectification, we are losing a lot. But I'm not sure about apologies as responses. These I have whether they have a place or not in the kind of litigation. So you may have a point there, but the only element I want to mention is that the idea of recognition is not an idea of reconciliation or nothing of the sort. Not only kind of understanding that one reconciliation with victims is not what the commission meant, and sometimes apology have understood it that night, others not. Yeah, you're the expert. Then we can discuss it. So yeah, that's with apologies. And then the messages of money is what I'm really interested in. I mean, I think that money sends different messages. It's not the same amount of money that you're giving for gratification, that the amount of money that you're giving for behavior. And I think the most vivid examples of this is what's happening, for example, in jurisdictions like Mexico and European jurisdictions that are hiding the punitive element under the umbrella of non-pecuniary damages. And so when you get at the end of the day, it's an amount of money for compensatory damages that actually harms the punitive element. And of course, there, the message of condemnation, the message of sanction is completely diluted in this kind of case. And so I'm trying to look at this. What are the good reasons to distinguish sanction from compensation? And there, the message of money comes immediately into the picture. Because one of the elements in this is the expressive message of money. It's not the same amount of money that you pay the negligent car accident that caused physical injury to the victim than you pay because of the reprehensible behavior that was mentioned, this corporation charging excess. Just to give an example. And this then, the terrorist messages that are different. And so, yeah, the expressive message of money, I think there is much more there, and I think it will develop. And I'm trying to see whether this is a justification to do this line between sanction.
I just wonder, sure how to formulate this, so I've been avoiding it. But I wonder a bit about, I think recognition and outrage can be very different things. Unfortunately, I'm over-influenced here by the fact that when I think of outrage in the United States, I think Donald Trump, who can then spend his entire life being outraged, it's outrageous that he saw it. But it's also the case that emotion often is something that overwhelms you, and when you're really in the grip of an emotion, you've lost control, understandably, and so on. But we wouldn't actually generally tell people, yeah, it's going to take 10 years to litigate, try to stay out of control for all the 10 years. So the litigation is doing some kind of translation. And I think recognition is a very different thing. And I think for you, recognition is the best notion. And you're making me think I didn't understand recognition better because of what you're saying. So I hope I'm just pushing you on a down path you're already going. But the recognition is that the money damage award calibrates the seriousness of the misconduct by the defendant. It creates a public record of the seriousness. Like even if it's reduced, it doesn't really matter because what the media is fascinated by is the fact that it's $5 million to begin with. They're not going to report the reduction. That's really boring. And so it's the creation of this, and it's the fact that you'll get this kind of attention and there will be a public signaling that that's the really important thing from your point of view.
Yes, thank you very much. I'm connecting with Diego's example again. Thank you, Diego. And I think of the idea of recognition in a slightly different way. That it has to do with the idea that you as the victim, you are the one who has the power to subject the defendant to the sanction, to the imposition of the sanction from the judge, right? And so this is the idea of recognition, the fact that you can be the one who can change the state of affairs. Diego is the one who can change the state of affairs by filing the lawsuit. This is the idea of recognition, affirming her value as we're equal. The fact that, okay, you can do that to me, and what I can't do is file a lawsuit to change your behavior, to sanction your behavior. We can discuss the motivation, but this is basically the idea of recognition that I have in mind.
Which is the legal standard.
Well, good question. It's because I don't talk about standing, but power. And so there, I think there is a distinction between the standing and power. And so the idea of recognition comes connected to the idea of power. The idea that you can subject the defendant to the jurisdictional power of the court. And then what it comes out from the game damages is the new debts that they owe to you, that before didn't exist. But because you activated that, then it comes to exist as such. And also the idea that whether this is the right, the power is the right or not, because the idea of standing is based on the idea of having rights. And I think there is a distinction, important distinction there between having the right to impunity or the power. So when I'm more arguing for the power to be given, in the sense that the court has not has not the duty to grant you, but yes, to consider your claim and see whether this is the case. And so there is a distinction here between the standing and power. Not completely. Is that to the recognition?
That all makes. Yeah, I was just thinking of that as power. I was thinking that of power. I think that is a very nice way of putting it, because what you're doing is exercising power, returning the wrong done to you with some. Version was his favorite case. That feels like our case, but it's that the money, the size of the money award doesn't seem to be about the exercise of power. It seems to be about the marking expressively of how bad the conduct is. I think you want that too.
Yeah, a proportionality of sanction. Yeah. Yeah. One thing is the recognition of the power, and the other thing is how much for it. How much for the sanction, and their proportionality comes into the view because we're talking about sanctioning and retribution. So that is an important.
Thank you. Now we will be having our lunch. Remember to all the conference that the lunch is during the university and it will be in Casa Externa. The rest also have a great lunch, and we will see everyone at 2 p.m. for the last conference of the day. Thank you, Professor Maria Guadalupe, for your conference, and we will see you at 2 p.m. Thank you.
Thank you.
Sí, aquí abajo.